Yes. Next. Page wise, Jiba.
Item 4.
Page number
Page-
1, item
page-
number
Please, Your
2 to 5.
I want to mention a matter. It's writ petition 8619 of
Please
24.
give your memo. Please
Yes,
give
Your
your
Honor. It's
memo. You have
an
to file in the
interest
court.
custody matter. I pray your lordships that it could be listed tomorrow
No.
because
No prioritization on the basis of place of mentioning. The only distinction I can make is that you are not in the court, not in your chamber, you are in a vehicle. So that can't be a basis of prioritizing any memo. So give your memo. It will be taken care of. It's a fresh matter
Much
or
obliged.
orders or after notice you mention it.
much obliged.
Yes.
Page number 1, item number 2 to 5.
Item number 4 and file an affidavit.
You are Mr. Naik. आपका नाम है sir?
Well,
आपका नाम SK Barik. So SK Barik for the petitioner. After the matter was heard on 28/1/2026, and the petitioner had adjournment. Today it is dismissed. Today it will be dismissed. ଆପଣ ଟାଇମ ନେଇନଥିଲେ କି 28/1 ରେ ଜାଲି ବାବୁଙ୍କୁ ଡାକନ୍ତୁ କଣ ଓକିଲ ଚେଞ୍ଜ ହେଇଗଲେ ବୋଲି ଡେଟ୍ ଚେଞ୍ଜ ହେଇଯିବ ନା କଣ look at the order sheet. ହଁ ଠିକ ଅଛି ଆପଣ 28/1 ରୁ ଟାଇମ ନଉଛନ୍ତି କଣ it is at your prerogative. It is your prerogative to grant take adjournment. Yes. Kali tomorrow. Sir, Bangalore or US is not concerned. If I record, I'll reject it. It is submitted. So you are,
Last.
I did not pardon you. Why should I pardon you? Have you committed any crime? Yes. You are not agent of your client, sir. You are a lawyer. Bangalore client को importance नहीं होती. That is how you have been seeking and seeking pardon. Why should you seek pardon if the client is not listening to you? He should beg pardon from you for not listening. The matter was had at some length on 28/1/2026 and was adjourned. And the petitioner had adjournment to provide instruction. Thereafter, it was directed to be listed on 9/2/2026. Thereafter, no, it was directed to be listed on 9/2/2026. Thereafter, the matter was listed on 13/3/2026. Upon the client as question, don't entertain those clients. What is the difference between a henchman and a lawyer? Both are taking money, but you are a professional. You have an exalted position. Talk straight, talk the truth. Your effort should not be to manipulate the process to adjourn the matter. Then criticize the court for adjourning the matter. Who has been adjourning since 28/1 for the last 5 months? Court. Someday you have to take the responsibility, Mr. Bari. You are officer of the court.
Item 4, I am up for opposite party.
On 7/4/20, thereafter on 7/4/2026, the matter was deliberated at length. And order was passed. With the following direction. With the following further direction. Para 6 for sustaining the challenge to 75,000. 3,75,000. Thereafter, though the matter was directed to be listed on 4/5/2026, it was listed on 6/5/2026. And again, the petitioner had adjournment. Today, the matter being in the list, You are Mr. Ikke Mahanti, Mr. Raut.
My name Umakant Barik.
I'm sorry. Other side is Umakanta Barik. To the matter being in the list, under the heading fresh admission, at the beginning of the day's proceeding, adjournment is again sought for. The Lord Counsel for the petitioner is apprised of the pattern of seeking adjournment since 28/1/2026 for the last 5 months, which speaks volumes of about the conduct of the petitioner. Yes, Mr. Barik.
My lord, not paying the arrear amount, my lord.
Lord Counsel for the opposite party
My lord.
submits that though upon execution launch question,
Ha,
the execution has been filed in the pretext of pendency of the revision application. The petitioner continues to be in defiance of the order and remain in default of the amount due. In considered view of this court, this court has shown sufficient indulgence for the last 5 months. The petitioner's apparent strategy has been somehow to adjourn the matter, and in the process, the opposite party, having been granted the amount of maintenance, is not paid. The Lord Executing Court shall proceed with the execution in accordance with law. Copy of this order shall be forwarded to the Lord Executing Court by the registry. The matters आज कितने तारीख? Maji sir? July. The matters will be listed for fresh admission on 6/7/2024. ଆପଣ 2 दिन କହୁଥିଲେ ଆପଣ ଅଧିକା ଦିଆ ହେଲା. Get rid of these clients. This will never enhance your reputation. Must think about the other side.
my lord,
କେତେ ଟଙ୍କା ଆୱାର୍ଡ ହେଇଛି
75,000.
ଟୋଟାଲ?
ଟୋଟାଲ ନାହିଁ କ୍ୟାଲକୁଲେସନ ହେଇଯାଇଛି ପର ମନ୍ଥ
Calculation ହେଇଛି. ଆୱାର୍ଡ କେତେ ହେଇଛି?
15,000 ହେଇଛି.
15,000 ଟଙ୍କା ଆଜ୍ଞା ଆଜିକାଲି ଯୁଗରେ. You should not take that responsibility of depriving or putting somebody to difficulty. ତାଙ୍କ choice ଆଜ୍ଞା କେସ୍ କରିବେ ନ କରିବେ. Who are you? ଆପଣ there is a purpose, because I come from that side. I know how to handle because I have been handling very high profile clients,
My lord,
very high profile clients.
କପି ଗୋଟେ ସର୍ଭ କରିବେ ହେଲା କେନ୍ତା
କୋଉଟା କୋଉ
ଆଚ୍ଛା କପିଟା
କପି ପାଇନାହାନ୍ତି କହୁଛନ୍ତି?
ନାଇଁ ପାଇ
I could not follow that. Learned counsel for the opposite party requests for a copy of the application. The learned counsel for the petitioner shall serve copy of the application along with all connected papers by tomorrow.
Page number 2, item number 6 to 17.
Item number 7 on behalf of Mr. P.R. Singh, my lord. Let it be listed on next 2 weeks after. Item 7.
Same story, sir.
I am for the
The
wire.
MR Thola on behalf of P.R. Singh for the petitioner. Mr. Prem Kumar Mahanti, additional standing counsel for P1. The matter was had at length on 13/5/2026. The facts as well as the legal propositions were noted. And noted in the detailed order. Stop. Today, the matter being listed for fresh admission. Adjournment is sought for on behalf of the learned counsel for the petitioner. to grant further opportunity, the matter shall be listed for orders and for fresh admission in the week commencing. Satish sir, Maji sir, ଆପଣଙ୍କର ଏଇଟା ଅଛି list ଟା? Trying to ଗୋଟେ week ରେ adjust କରିବାକୁ ଚେଷ୍ଟା କରୁଛୁ, trying to adjust 133, 134, 121 ମାନେ ଏଇଟା specifically adjourn ହେଇଛି, ତା ଦେହରେ memo ଆଉ ଯେ add ହବ
Item number.
Oblige.
first page ରେ call ହବ, just wait. ଠିକ ଅଛି ସାର୍, ଆପଣ fresh admission ଆଜି ଯଦି ଆମେ ପଢୁନାହାନ୍ତି, try to address the court. Yes. ହେଲା ଠିକ ଅଛି ଆଜ୍ଞା, ମୁଁ ତ ଯାଇନି, I need to start, just wait.
Page number 3, item number 18 to 23. Page number 4, item number 24 to 30.
Apologies, I think I missed the second
Serial
list.
number?
Item 12.
12, page 2.
Your Lordship, my learned senior Mr. Mishra is under the weather, so I'm requesting for a short accommodation.
What's your name, madam?
Krishna Mishra.
Miss K. Misra, on behalf of Soumya Misra for the petitioner. The matter was had at some length on 11/5/2026. The facts as well as the propositions of law were noted. Stop. Today, the matter being in the list for fresh admission is mentioned at the beginning of the day's proceeding. Adjournment is sought for in absence of the blooded arguing counsel on the ground of personal difficulty. When do you want?
Your Lordship, any day.
The matter shall be listed for fresh admission in the week commencing 27/7 or 3 3rd August?
27.
Satish sir. ठीक है सतीश sir.
Page number 3, item number 18 to 23. Page number 4, item number 24 to 30. Page number 5, item number 31 to 33.
Item 32, madam.
Yes,
But
please.
this is a matter for release of pension by counting the past service. They have not filed counter. My counter is necessary in this matter. The government has not filed counter.
The counter OP4 has filed, but after the consolidated writ petition, they have not filed.
The counter, madam.
You okay? Just kindly wait and mention in their presence.
Yes, yes.
Like they will note that counter is not
Yes.
on this one, whatever it was. So, Trustee, last page.
Page number 6, item number 34 to 40.
Yes, but the petitioner mediation successful.
On success and for high return. Only my husband is getting 1.5 lakhs. 15,000 only interim maintenance of mother and doctor. That was challenged by husband. Subject to payment of 4,000 rupees as an interim measure. Now the matter has already.
So
been
let
over.
us wait. Let us see. Just inform Mr. Pradhan. Okay.
This matter is in the list.
No, it will be in the list because we are no. You go ahead with your work because it is unlikely to reach soon because I have to complete the fresh admission and orders. In some matters, it has to be hard at length. Okay,
My lord, item 36.
36, Mr.
In this matter, my lord may be recalled, my lord was specifically directed to list the matter in the orders. My lord, it has come again in the 36. I am not getting any maintenance and enhancement material. His getting annual income is more than 7 lakhs, but I am awarded with a 5,000 rupees, which is also not paying. So kindly.
You have to launch execution.
Unless
I understand, Mr.
Uh-huh.
I mean, this is the feature, Mr. Kara. This branch has completely been distorted. This maintenance jurisdiction has been completely distorted. The amount is not paid. They come to High Court. They do not pay. Execution is not proceeding.
my intention is for putting for
I understand.
for enhancement of the maintenance.
But let us see. in presence of Mr. Patnaik, if he comes.
My lord, kindly keep taking it in orders. My lord, specifically directed because there is a
So
one
let me see.
IA is there.
Just I can't simply pick up and post after notice matters for orders.
No, in the last day,
Mr. Koro, even fresh matters have to be heard here.
no, fresh
The
matter, my
nature
lord,
of-
fresh matter kindly
I
heard.
understand, even orders have to be heard. So let us see.
No, kindly
Every
put
matter-
any day in orders.
Every matter I put in orders, then becomes difficult.
This matter, my lord, was pleased to direct because IA is there.
The list becomes unmanageable. Let us see.
IA is there na for that.
Execution ର କିଛି answer ନାହିଁ in High Court. ଆପଣ ଯଦି execute
No,
କରିବେନି-
execute ପାଇଁ ମୁଁ କରିନି ମୁଁ କରିଛି enhancement.
when ଆପଣ ଯଦି execute କରିବେ ସେ 4000 ଟଙ୍କା ବି ଦଉନାହାନ୍ତି, then you should file execution.
For enhancement.
Supplementary list. Item number 1.
I beg your pardon to make mention, my unit senior. Item 32.
Yes, Mr. Lenka, he was mentioning item 32. 32, he says counter has not been filed and he has sought for pension. ଦେଖନ୍ତୁ ଟିକେ ଯାହାର ବି ଥିବ,
Yes, I'll take.
yes,
Lordship calling.
ଜଣେ DGAଙ୍କର brief ନ ହେଇପାରେ, ଯାହାର ବି brief ହେଇଥିବ, he will take date କେବେ ଆସିଲେ ହବ?
2 weeks after.
32 ଟା କରନ୍ତୁ, we commencing 3/8. ଆପଣ କମ୍ପ୍ୟୁଟରରେ କରିଦେବେ. I am not passing any order. କମ୍ପ୍ୟୁଟର ହେଇଯିବ ତ ଜାଣିଛ?
हाँ.
So that time save ହବ. Yes,
Item number 1.
Mr. Panda.
Last time I directed to government to take instruction to send others into mediation or not.
Any instruction, Mr. Lenka, mediation ପାଇଁ? କରନ୍ତୁ mediation.
My friend, my senior will agree, then it will be sent to mediation.
ଆପଣଙ୍କର ସ୍ପେଶିଆଲ ଯୋଉ ସମାଧାନରେ ବି ଲେଖା ହେଇଛି ଲ୍ୟାଣ୍ଡ ଆକ୍ୱିଜିସନ ସମାଧାନ ଯୋଉ ଏବେ apart from mediation point 2 2.0
No instruction is issued by the.
Mr. M.K. Ponda for the petitioner. Here, who is appearing? You are appearing or Mr. Mahanti?
Prem.
Mr. P.K. Mahanti, ASC for the opposite party. The learned counsel for the petitioner refers to the appellant actually. The appellant. Appellant is what? The learned counsel for the appellant refers to the earlier orders directing the state to obtain instruction regarding referring the matter for mediation. It is submitted by the learned state counsel that the instruction is awaited. So, the matter shall be listed under the same heading in the week commencing 27/7/2024. The earlier order directing to obtain instruction for referral of the matter to mediation is reiterated.
Last chance.
Last chance upon mediation LAC and also hearing over. So let us see. Last chance कौन होगा?
चिट्ठी पिठी को चिट्ठी
Mediation में हबनी आपको करें.
चिट्ठी करले सिना चिट्ठी करूना
एक पुनी. Yes, next.
Item number 2.
माने ticket of 5 years कौन को जाए? माने ticket of the ticket of adjournment 5 years of adjournment it's not adequate. The matter was presented before this court on 16/7/2021. Since then, the effort of the petitioner has been since then, the matter remained defective as pointed by the SR. Till the order dated 9/4/2026, when the matter was taken up for the third time. On 5/5/2026, the matter was again adjourned by the petitioner. Apparently, for the last 5 years, the only effort of the petitioner is to adjourn the matter after filing the same. without there being any order or the matter having been admitted. The copy of this order shall be forwarded to the Learned Judge Family Court Fulbani to be kept in the records of CRP 70 of 2020, disposed of by judgment dated 3/5/2021. Any execution, if pending, arising out of the said petition shall be proceeded with in accordance with law. Yes, next.
Item 3,
Please, Your Lordship.
Your name, sir?
On the last occasion, Your Lordship directed to seek instruction from the
Appointment
petitioner.
matter, sir, called
Hemanta Mahanta, Your Lordship.
Mr. Hemanta Mahanta for the petitioner.
We have paid the amount, Your Lordship. Today I am filing the order.
Affidavit you are filing.
Yes.
The Learned Counsel for the petitioner refers to the earlier orders. Earlier order dated 12/3/2026. Kudiye 5/2026 to submit that the petitioner has deposited amount towards the maintenance as directed by the Learned Judge Family Court, Raurkela. So, he submitted that the petitioner is filing affidavit. The affidavit shall be filed in the registry, scanned copy be updated. The matter shall be listed for fresh admission in the week commencing. Okay. 6/17/13 के पे करिए फाइल है कि स्कैन है क्या 13/17 yes.
item number 5,
Mr. Udaranda Mahapatra for the petitioner. Trivedi Nahanti pass over कर दवा.
Again,
Can it be passed over? The other side is not present.
other side can appear करें notice ही नहीं था.
Appear करछन्ति त ना आपण सी आगुरा पिटिशनर पे appear करथले
No, no, I am for the petitioner. Respondent. Yes, appeal.
Mahapatra, can you accommodate him for some
Huh?
time? So if he comes, then you ask your Learned Junior to inform me. Okay, pass over कर दो. Yes.
item number 6,
Appear pretty well.
Filer on behalf of Mr. Roy.
Mr. Acharya ना, Mr. Dwivedi.
No,
नहीं, नहीं.
Six.
He said 6 appear करछन्ति.
2 weeks after.
Your name, sir?
P.K. Samanta Singhar.
Mr. P.K. Samanta Singhara on behalf of Satyanarayana Brahmara Rai for the petitioner. The matter was had at length on 1/5/2026. Had at some length. The propositions of law were noted. The petitioner had adjournment to address on the issues noted. Today, the matter being in the list is mentioned, adjournment is sought for on behalf of the Learned Counsel for the petitioner to grant further opportunity. The matter shall be listed in the week commencing. 27/7 ना 3/8 केबे
3 कम अछि 3
3/8 सार करो इच्छा अछि नै देखियो
Sir, August को रहो sir.
हां बुझले ठीक अछि.
item number 8,
पासवर्ड कर दियो तो
item number 9,
पासवर्ड.
item number 10,
Your Lordship, and for the petitioner.
Akanksha Kabi for the petitioner. Yes, Ms. Kavi.
Your Lordship, I filed this transfer petition to transfer the divorce case from Family Court Baripada to Family Court Bhubaneswar. After the decision of the party, the wife from the husband, the wife along with a minor child are staying in Bhubaneswar since 2023 because at her parental
How many
place.
cases he has filed against the husband?
Your Lordship, she has filed the maintenance case, which maintenance, the final judgment is already over. The judgment is pronounced and an arrear of more than rupees 3,76,000 is pending in that case. Only 20,000 rupees he has paid till now in that case. A DV case has been filed in Bhubaneswar itself, and in that case also an total arrear amount of more than rupees 2,50,000 is pending till now.
The 125 CRPC or 144 BNSS and
Yes,
the DV case, they were not taken up together.
Your Lordship,
There are several separate orders.
yes, Your Lordship, there are separate orders. The maintenance case was filed in Baripada way back when she was deserted. And the DV case was filed in the year 2023 after she and
They
her...
have not filed any execution of 125.
Your Lordship, both the executions for both the cases are filed in Bhubaneswar. Even for the Baripada order, because it is not convenient for us to go there and fight our case there, we have filed the execution case of the maintenance also in Bhubaneswar. And he has... No 490-day cases are pending, Your Lordship. She wanted to reconstitute her marriage
So
for the sake of
not
time.
correctly.
Your Lordship?
Because usually after they meet the lawyer, the number of cases increases.
No, Your Lordship.
After wife being estranged from husband, they meet the
Yes.
lawyer.
Your
Usually
Lordship.
the number of cases that goes on increasing.
Your Lordship, we have
Take notice.
she wants to restitute her marital life, Your Lordship, because of the sake of her
For the best.
minor child.
Hard learned counsel for the petitioner. The petitioner before this court is the wife in the marriage. You take your seat, I'll dictate the order.
Yes, Your Lordship.
The petitioner before this court is the wife in the marriage. 6 transfer of the CP number 227 of 2025. Pending before the Learned Judge Family Court Baripada to the Court of Learned Judge Family Court Bhubaneswar. But here both the persons they belong to Baripada actually.
Your Lordship,
I think the husband is a bank employee in
State Bank of India. State Bank of India. Your Lordship, the father of
Let us see, let them respond.
Yes, Your Lordship. The father of
Yes,
the
sir.
wife was working in
The
Bhubaneswar.
CP has been filed by the husband in the marriage under section 13(1), 13 into bracket 1, capital A into bracket English, Roman small 2, read with section, comma कर दिया तो section 13 into bracket I dash small a, I dash into bracket closed, I dash small b of the Hindu Marriage Act, seeking dissolution of the marriage solemnized on 2/7/2018. Have they filed written statement that this is not maintainable? Have you filed?
Your Lordship, no, we haven't yet filed, Your Lordship.
2/7/2018.
We have appeared in the matter.
And grant of decree of divorce. It is submitted that after the marriage has run into rough weather, the petitioner wife along with the minor son stays with her parents, let's say.
Yes, Your Lordship.
With
Father
the
was
parents
working in
at-
Bhubaneswar.
At Bhubaneswar. The order directing payment of monthly maintenance issued passed by the learned court at Baripada under section 125 of the CRPC is not complied with. The arrear amount is about 3,65,000. The petitioner, due to lack of maintenance, is distressed. So it is submitted that subsequently, application in section 12 of the Domestic Violence Act was filed before the court at Bhubaneswar. In the said order, in the said proceeding, the amount directed to be paid is also not paid by the husband with opposite party. Stop. It submitted that the petitioner finds it difficult to attend the matter at Baripada. Stop. Issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within
3 days.
within 3 working days. The returnable date be fixed to 27/7/2026. The matter shall be listed for orders in the week commencing 3/8/2026. Then IA 162 of 2026. Hard running counsel for the petitioner. She reiterates her submissions as noted above. Stop. Issue notice to the opposite party as above. Accept one set of process fee as well as postal requisites. Stop. The returnable date as well as the next date of listing shall be as directed above. Stop. Para, in the interim, it is directed. The CP number 227 of 2025 pending before so and so shall be adjourned to a date beyond 10/8/2026 as would be convenient to the learned court in season of the matter upon a prayer being made for the said purpose. Urgent certified copy be granted as per rules. Yes, please. Next.
11.
Mr. Ray,
My lord, in
what is happening?
direction of this honorable court, since last 2 dates, no copy.
Se kon nije asunanti kon adi kon hochi ni buझी पार पासवर्ड कर दबा ठीक है समस्त पासवर्ड दिया होची तम yes next
Item number 13.
13 Mr. Das Naik. Mr. Radharaman Das Naik for the petitioner. Yes, please. Opposite party black. Yes, Mr. Das Naik.
Suppressing the fact that petitioner is one of the legal here. That was not mentioned, and by suppressing is select, suit was filed, and a compromise suit was filed. And supplement is dispatched.
You are not made a party. Take notice. Hard learned counsel for the petitioner. The petitioner in the writ application challenges. The order stated 13/9/2022. We don't know. 19/10/22 কোটি চ্যালেঞ্জ করছন্তি প্রেয়ার রেকর্ড আছে সে আমাদের order dated 12/11/2022 passed in the National Lok Adalat in CS number 546 of 2022 by the learned civil judge into bracket senior division Baripada. तो सिविल जो सीनियर डिवीजन लिखे ने तो चेंज करी लिखो तू सीनियर सिविल जज Baripada. It is submitted that it was a suit for partition. It was a suit for the suit was for a partition of joint family property. Of joint family property. The petitioner is a legal heir of the kahara legal heir apano. Plaintiff, defendant, specify karantu. The petitioner is a legal heir of
The common ancestor Boroda Kisku.
ଆପଣ ସଲେମାନ କିସ୍କୁଙ୍କର ଲିଗାଲ ହେୟାର
I'm not taking Jonathan son. Case 7 file. Case 7.
କୋଶ୍ଚିନ୍ଟା ବୁଝନ୍ତୁ ଯୋଉମାନେ ଟ୍ରାଏଲ କୋର୍ଟରେ ପାର୍ଟି ଥିଲେ ଆପଣ ତାଙ୍କର ଲିଗାଲ ହେୟାର କି କୋ ସେୟାର ସେଇଟା ପଚରା ଯାଉଛି କିଏ ସେ କୋ ଡିପେଣ୍ଡେଣ୍ଟ ପ୍ଲେଣ୍ଟିଫ ସିଧା ଯାଆନ୍ତୁ ଆପଣ ସୁଟର କଷ୍ଟ ଟାଇଟଲକୁ ଯାଆନ୍ତୁ मरियम किसको फाइल कले सलेमान किसको so Mariam versus Saleman.
Saleman is the mother of the petitioner.
Saleman maga son of so and so mother केमती ही जिबे आगे father ही पारंती
Mother file कले against the son.
आपण how you are related to Mariam or Saleman?
I'm the brother of the Saleman and the son of the Mariam.
Who was passed away? Jagannath किसको?
Jagannath the husband or husband of the wife. After death of Jagannath, I have filed suit against the one son.
ठीक अच्छे वो सेटा अपन तो कहू ना तो कौन लिखले the plaintiff. The plaintiff, she being the mother, the petitioner being son of late Jagannath Kisku, husband of the plaintiff, Salman Kisku, Selman, S-A-L-E. Selman Kisku is son of Jagannath. That is very interesting. Even they also have the name of Jagannath. Oh, I'm sorry. Jonathan. Mr. Haveli, I was wondering. Jonathan. J-N-A-T-H-A-N. Duty Jagannath देखी तो Jonathan कर देते हैं. He submitted that the petitioner, अब इतने के जन petitioner अचल, Samuel आकी अचल, जाने. The petitioner was a necessary and proper party in the suit for partition, which was filed behind his back. Compromise decree was also filed, and has been settled by the National Lok Adalat. Para. In considered view of this court, the matter needs to be heard in view of the law laid down by the Honorable Apex Court in. My lord. In view of the law laid down by the Honorable Apex Court in State of Punjab versus Jalor Singh. So notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 2 weeks. One. Because within 7 working days. List of the returnable date be fixed to. Maji sahab ko hame 37 jaye korchu nahi sei 3/8 re kariba to fix to 27/7/2026. The matter shall be listed for orders in the week commencing 3/8/2026. आइए फाइल करचंती.
Item number 14.
आपण किंतु respondents को जो opposite party दी जणो करछन जणो करछन. आपण लीगल हेयर लीव नहीं करे कथा नो एटा बर्तन नोटिस बर्तन चालीला. सेलमैन नोची कोन इशुलेस. तो आपण खाली मरियम को कले. बुझो नले बर्तन अगेन टीवी से जो एडजमेंट हो फिर आउटर नोटिस इशू हो. आपण बुझी पर नाली मो कथाटा आपण मदर को तो नोटिस गला जाई सलाणी जीव कोन को जाई सलाणी. आपण जदी अदर पार्टीज को एबेठू लीव न ले कि आपण इशू नोटिस न करिवे दिस प्रोसेस विल कंटिन्यू.
I have filed death certificate along with legal certificate.
तो बुझे हबनी कोन डिस्कशन चलची. Is it the question? I am asking you should satisfy yourself that everyone, since you have already raised this issue, that all the legal heirs are not parties. In the suit, in the writ petition, if they are not parties, the same issue remains unresolved. So that was the query too. If you are confident, so it be. Upon the confident authority that you have proper instruction.
I could not party because one of the definitely.
So that's like it is too obvious to understand. Now Mariam will come, she will appear, she will say that Jonathan had two other legal heirs. That is the probability I am trying to explain to you. Upon got a legal heir file karchi, se dies issueless. When this kind of a problem has arisen once, there is a party who was the legal heir, he should have been made a party, he has been avoided. Perhaps you are saying that. So after now Mariam will appear and say that apart from Jonathan, say David and Tom, Dick and Harry all are not made parties. So that I wanted to tell you. Because ultimately, what is the result of this petition? It has to be remanded.
Right.
It has to be remanded for improvement of this. Here the petitioner is whoever is the petitioner, Samuel. So that saga should not continue. That is the concern, because this keeping this matter pending is of no use actually. It has to be tried again afresh by hearing Samuel. So that you anyway. Let us see.
May I please your lordship?
Item number 14.
May I please your lordship?
You are
On
Mr.
behalf of-
SK Mahanti.
No, sir. No, my lord. I'm Vishal Samantara.
Mr. Vishal Samantara. You are writing B.
B.
BISHA. Mr. Vishal Samantara on behalf of from PC Jenna for the petitioner.
Sir, praying for on behalf of my learned senior, praying for an adjournment.
Mr. Lenka? DN Lenka AGA for
All job.
for opposite parties. Adjournment is sought for on the as it was done earlier on 30/4/2026 by the learned counsel for the petitioner. Adjournment is again sought for in absence of the learned arguing counsel. To grant further opportunity, the matter shall be listed for fresh admission in the week commencing 6/7/2026. Yes, next.
Item number 15.
So,
Item number 16.
On item number 16, we seek for an adjournment.
your name? You are?
Pragati Jaina, on behalf of Sujata Jaina. ma'am.
Yeah.
Pragati Jaina.
Pragati. I'm
Yes,
sorry.
yes, sir.
Ms. Pragati Jena on behalf of S. Ponda, Learned Instructing Counsel for the petitioner, opposite party blank. Adjournment is sought for in absence of the learned senior arguing counsel. When do you want? The matter shall be listed for
After-
fresh admission in the.
After a week.
The matter listed for fresh admission in the week commencing 27/7/2026.
For orders, item number 17.
Your lordship, on the last occasion, please, I am VC, your lordship.
Yes, please. Mr.
My lord. On the last occasion, your lordship directed my land friend to take instruction because they wanted some time. I don't know whether they have given the instruction or not.
No, you file it with the affidavit, bring it on records or copy.
Yes, yes.
Do that, please do that. Mr. Narendra Kishore Misra, senior advocate, along with Ms.
Adesha Annapurna.
Adyasha Annapurna for the petitioner. Mr. S.S. Rao, senior advocate, along with Mr. B.K. Mahanti for OP3. OP1, Mr. D.N. Lenka AG.
1 and 2.
1 and 2.
1 and 2.
1 and 2, Mr. D.N. Lenka AG. 3, Mr. The learned counsel, it is submitted by the learned counsel appearing for the OP number 3 that he has received instruction. He shall file it supported by affidavit and serve copies on the learned instructing counsel. Within how much time, sir?
1 week.
Within 7 working days. The matter shall be listed for orders in the week commencing 27/7/2026.
Yes. Again, take it. Take it. Grateful.
Mr. You have received the cost.
Yes, ma'am.
18, Mr. Anshuman or Mr. Anshuman Sethi, Additional Standing Counsel for Appellant, Mr. Mohammed Faradis for the respondent. As directed by order dated by order dated 12/5/2026, cost of ₹500 has been paid by the appellant. Accordingly, the delay in filing the appeal is condoned. You should notice in the appeal In view of appearance of the learned counsel, आपण करिवे तो?
My lords.
In view of the appearance of the learned counsel for the respondent, so further notice be issued. Copy of the appeal memo along with all the papers shall be served on the learned counsel for the respondent within 3 working days.
Yes, sir.
LCR be called for. The matter shall be listed for hearing in the week commencing 3/8. The learned additional standing counsel as well as the learned counsel for the respondent, additional standing counsel for appellate are requested to take up to pursue the matter for settlement by mediation. The liberty is granted if any progress is made for achieving a mediated settlement. Chesta karantu. Wherever you are having this kind of matters, as you have marked this Samadhan by Supreme Court, mediation for nation 2.0, land acquisition is mentioned. So please mention in your letter. It's kind of a template you add to it, and if you can achieve anything, you inform Mr. Faradis and let us see.
Item number 19.
Right. Mr. You are Mr. Patnaik, Mr. Mr. S.R. Behra on behalf of Pratap Chandra Mishra for the petitioner. Mr. Manas Kumar Chand for the opposite party. कौन पूछ रहे थे मिस्टर? ये रे आपण तो से स्टे नहीं थे मेंटेनेंस है कौन आओ
10,000 मास्को हिची and he is an alco engineer.
दियों तू ये जो जिनसटा है at least you are clear on this that you must be clear by this now because I have deliberated in so many cases, so many orders, judgments that this cannot be. दौचुंती अच्छा affidavit दियों तो ठीक है the learned counsel for the petitioner request for copy of the IA
Already served.
24
Already served. Just now, sir.
which is served on the learned counsel. He submits that the amount of maintenance is being paid by the petitioner
Regularly.
He shall file affidavit giving the details in brief, such as the date of payment, amount paid, mode of payment, and the total amount paid. The matter shall be listed for orders in the week commencing 37. Satish Sate, he shall file affidavit giving it so and so upon serving copy thereof on the learned counsel for the petitioner. Interim order as past interim order dated date shall continue till the next date of hearing.
Item number 20. Item number 20.
Pass over.
21.
I'm on VC Miller. I beg to appeal for one of the opposite party.
So Satpathy Kwana Nandi, Mr. Muti, kindly have your seat, no difficult.
Beg your pardon, sir.
You kindly have your seat. Okay, now you are visible.
Yes, Miller. This is actually, there is another possibility of actually mediation. If mediation done, there's a possibility because the judgment which has gone in favor of this respondent, opposite party, she is agreeing to give something to the appellant. She has agreed. But 30% debi boli kahila, sir. She is the only daughter, even though, but she has agreed to give.
Sir, shouldn't you upon na kono sir? Power nahi. Get some power upon us. Sir, Anil Kumar Barik on behalf of PK Satapathy for the petitioner. Appellant, I'm sorry. Appeal petitioner, the Cordebe appellant. Item 21. First, like Mr.
T.N. Murthy, sir.
Learned counsel being present in VC addresses arguments from Jaipur.
Koraput, sir. I'm here at Koraput.
At Koraput. Your appearance होचुंती opposite party पर देखी लिखते हैं, respondent लिखते हैं. It is submitted by Mr. Murthy upon instruction that the respondent number. Mr. Murthy, you are appearing for all the respondents.
Yes, my lord. Actually, the respondent is only The, so I'm ending.
Sure.
She is the only one respondent. Below.
Acha, only respondent. It is submitted by Mr. Murthy upon instruction that he has talked to the respondent who is inclined to share the amount of compensation up to 30%.
Yes, Miller.
Shall I record it or it will be difficult for you? Okay.
Because I have
She is inclined to accede to the prayer made in the appeal by the appellants to have a share of the land acquisition compensation. ଆପଣ instruction ନିଅନ୍ତୁ persuade କରନ୍ତୁ because ସେମାନେ ଯୋଉ ଜାଗାରେ ଆସିଛନ୍ତି ଯୋଉଠି ଅଛନ୍ତି they can't sustain litigation and it is pending for 2 years. It may remain pending for another 20 years. So at least if they get the amount, talk to them. You have heard your learned senior, so you talk to them, and if they accept, so at least they will be having something in their hand. That is how.
My lord, I am appealing, sir. My senior is proposing how much, sir?
about 30%, nearly 5 lakhs will come.
30%, it is difficult. That was the at least 45, 55. It will be reasonable.
About 30% they will be having this at their hand. Otherwise, the litigation will continue.
They continue. That was the mediation. That's why it failed.
Because it's 35. Mediation fail mediation.
It was the suggested amount before the mediation.
What you are suggesting? 35.
I am 45, 55.
Yeah, right.
45, respondent 45, appellant 55.
Appellant may be 45, they may be 55.
My humble submission is, she is the only daughter of.
Satpathy is saying that the appellant may keep 55 and respondent may have 45.
Respondent may be 55, so that they will get more amount. They have a satisfaction. We have also a satisfaction.
60-40 कर दियो Mr. Satpathy. As you would have marked that I am not recording anything.
I will take instruction.
60-40 रे राजी है जात.
Okay.
तैयारी करके फाइल कर दियो तो and close it.
Okay.
5% पाई.
ठीक है. I will persuade my client.
If you consider the devaluation of money and inflation,
Okay.
so it is a win-win situation for both.
And that will create also atmosphere, good atmosphere between the parties.
Absolutely.
Okay.
But I mean the huge litigation never ends.
Now the liquidity cash should not be a
in fact,
the hurdles for relationship.
Money will reduce because both sides are happy. When it should come?
Next week, my lord, I will simple the telephonic instruction and then I will.
Theory कर दियो तू.
Okay.
Affidavit कोड़े theory करी in consultation with Mr. Murthy. Wait, you have the number of Mr. Murthy?
Maybe sir.
I have to share.
It is making later.
9 आगे हम share करने भी आप लोगों को.
Sir, more number तक वो appeal member लेके sir पाई हुए. साथ में share करते ना वो petition भी पठे दी sir.
आगे.
अपना इटा settle कर दियो तू.
Again, sir, I will, 40-60 I will try.
They belong to a very remote area.
Man.
They hardly understand the nuances of law.
Actually,
uneducated also.
The respondent is the only daughter of the recorded tenant. ठीक है, कर दो.
Yes.
आगे. Much obliged.
The interim order dated so and so shall continue till the next date of hearing. The matter shall be listed for orders in the week commencing. Odisha te na Satisha te.
Any.
Satpathy.
Odisha.
Okay.
Yes.
Item number 22.
52, my lord, I am for the petitioner.
Mishra for the petitioner.
My lord, there was a, both the parties, husband and wife were
Sanjeev Mahanti for the opposite party. ଆପଣ ଏଟା ବି ସେଟଲ୍ କରିଦିଅନ୍ତୁ।
settle ଆଜ୍ଞା ହଉନି ସିଏ
ହବ ଆଜ୍ଞା, ଆପଣ
ଟର୍ନ
ଚାହିଁଲେ
ଅଫ୍
କଣ
କରୁନି ଜମା। ମୁଁ ତାକୁ ଆଜି ବି ଟ୍ରାଏ କରିଛି।
ଚେଷ୍ଟା କରନ୍ତୁ ଏବେ ତ ଆଜ୍ଞା ଏତେ ଦିନ ପରେ ଫେଲ୍ ହେଇଗଲା। Just saw that they are they belong to scheduled tribe community interior of Rayagada. They can't come to sit Jaipur ରେ mediation ହେଲା fail ହେଲା। ବର୍ତ୍ତମାନ ତ ଫେର ସେମାନେ ବୁଝୁଛନ୍ତି। So never it is never late to arrive at a mediation settlement.
Your lordship several occasions. He did
Nah,
not respond.
I understand.
That is the problem.
I understand, Mr. Mahanti, but it is worth doing it. It's worth spending time. It is better than spending time in mediation than in litigation. Because I'm not observing when I mean this way or that way. I'm not observing, but kindly make your efforts.
No instruction from the client.
कौन कराଯିବ ये तो ଶୁଣୁନାହାନ୍ତି client
The message ବି କରିଛି ଟେଲିଫୋନ ରେ।
client ଆପଣଙ୍କର ଏଟା lawyers brief କଣ କେହି ଶୁଣୁନାହାନ୍ତି lawyer ବି ଶୁଣୁନାହାନ୍ତି
ନା lawyers ବି
Lawyer
direct
petition
client
କରନ୍ତୁ।
direct client ସେ ତାକୁ ବି personal appearance ହେଇଥିଲା ସେ appear କରୁଥିଲା ସେମାନେ agree କରିଛନ୍ତି separate ହେଇଯିବା ପାଇଁ compensation amount ଉପରେ ଥିଲା issue
13B file କରନ୍ତୁ 13B file କରିକି
ତ କଣ turn କରୁ
ଦେଖିବା court can be harsh
ଆଜ୍ଞା
being harsh is not difficulty but let us see Mr. Vibhuti Bhushan Mishra for the petitioner Mr. Sanjeev Mahanti for the opposite party the office note put up by the registry indicates that joint affidavit indicating the terms of compromise not received. Stop. The learned counsel for the petitioner submits that despite his efforts, the petitioner is not responding.
Yes.
Stop. He seeks further time to obtain instruction. Stop. Accordingly, the matter shall be listed for orders in the week commencing 27 na 3/8 27 2026
ଲେଟର କରିବି ତାକୁ
ଦେଖନ୍ତୁ ତାକୁ ତାଙ୍କର ବେଟର ହଉଛି ଆପଣ ତାଙ୍କର ଗାର୍ଡିଆନଙ୍କ ସାଙ୍ଗରେ କଥା ହଉ ଯେତେବେଳେ ଆପଣ ଦେଖିଲେ ଯେ ଜଣେ ଶୁଣୁନାହାନ୍ତି you should talk to somebody who may have an impact on their thought process.
Oh, I have tried to her mother to contact her but she is not also not
I understand it becomes difficult for a lawyer also. ଆପଣଙ୍କ busy schedule ଭିତରେ ଆକୁ ପଚାର ତାକୁ ପଚାର but it is worth doing actually because you are doing something good for both of
society.
Typographical error ରହିଗଲା the ଲେଖନ୍ତୁ the registry has spotted out typographical errors in order dated 8/12/2025 and 12/5/2026. The serial numbers of the said orders shall be corrected as per rules in the order sheet. Stop. ତାପରେ order ଟା ଲେଖିବେ yes next
23
Mr. पुष्टि थिले कॉल करिवे पासो
24
to submit this senior advocation along with Mr. Rautre.
Rakesh Raut.
Mr. Rakesh Raut.
I'm sorry, I'm there.
Mr. Naik taki thile jone other side time thile
I think my learning name Mr. Pujari
Pujari was happening. He had some difficulty, health issues. So Mr. Naik sought for adjournment on the last.
They are seeking for adjournment. Nothing to say because I have got an interim order in my favor.
So should I pass it over or simply adjourn to another?
I am praying for another date because I will be in difficulty.
Okay.
Very badly placed, your lordship.
Opposite party none. Learned counsel for the in absence of the learned counsel for the opposite party, the matter is adjourned for to be listed for orders in the week commencing 27.
Madam, I out a prayer courtly. Your lordship may list it for disposal because can I try
hopefully even orders matter I am disposing of. But let them appear.
हमारे orders for
orders से थाउ देखिए ଆପଣ
आगे
और for admission कुछ देखो for admission करता
for admission हेले कौन में disposal है
for admission
can I try तो सेटा first week of August की क्या बुक
in the week commencing 3/8/2026
आगे
interim order dated so and so shall continue till the next date of hearing.
Obliged.
Next please.
25
If I am the petition.
Yes, Mr.
The only challenge is
Sanjeev Chakraborty for the petitioner. Mr.
the only
KSP
challenge
Tripathi. You are Mr. Tripathi. I'm sorry.
DC Rao.
Mr. DC Raut for the opposite party. Yes, please.
My only challenge is, as for Rajnish versus Neha,
From the date of.
from the date of filing Havagata, he is from the date of order.
Yes.
To that respect, I have no comments to this or objecting this. But so far as already I have filed many objections that both are residing senior citizen, both are residing in one flat, under flat. And even though I have filed my asset liability before the trial court, my cross-examination was expunged. I have not given an opportunity due to my ill health, as because I am suffering in a cardiac problem and undergone the treatment. And while the video conferencing date was fixed, so far as Western court is concerned, civil court, I am not able to appear on for the video conferencing to face the cross-examination. So my sole submission,
Did you challenge that?
I am not challenging.
So then, how can I?
No, now
More case na takar order can go.
Petition ne kone ithre the cross revision nahi paribo.
No man.
Which pale ki cross appeal nahi pare, but cross revision na concept nahi. Se jo apanakara jo order hai apanakara expunge hala. There are good reasons. And cardiac problem cannot be a ground for setting aside a order, expunging your cross examination. It is the expunge na thiyo.
Na. He asile. Cross examination face kale. Tapore okilo dele nije gar padile. Tapore gale petition patheile registry portion.
Cross examination heithila na heinothila.
Ha heithila kiso tapore se padile. Padila pore
se portion ne apanakara setiki portion ne apanakara expunge hei gala seta.
Na subsequently
tar decline hela jetu se face kale ni.
Decline korthibe.
Not decline.
I was pointing.
No my lord, the order judgment is so
challenge kale ni seta setole opportunity palela.
Taku challenge kale ni final order to be challenge karna thi.
Challenge, but subsequently the judgment itself of the trial court shows that cross examination of the opposite.
Aye, see kono apon pachare godebe. हठात देखिए डैश रोड है कि आपण जाउचंती लॉर्डेड कोर्ट
आपण आश्चर्य हेबे
होची भी
ना आगे से कदा भी नहीं
when I am supervising the performance in the trial court at times it is so difficult से कहबे जे आगे हम अच्छे हमको कोर्ट रे चलची से तू जज देखिबे सीसीटीवी रे से कोर्ट रे के नांती लागे आपण तो सेठी नांती कि जे कोर्ट खाली अछि आपण आसंतु एठी आसंतु so ये भी चली थी तेणु that is not possible.
My sole submission, further submission,
that is how the provision is made in the CPC due to non-cooperation of the client and matrimonial matters. It is difficult.
So
clients are not listening.
As because both are after 27 years, those 125 application was filed by wife, they are both are in senior citizen state. So make it compromise. Both are residing in under one flat. And
compromise maintenance आपण देबे की मु तो देई परिबेनी
no
तो आपण से फाइनेंशियल एस्पेक्ट रे मु कोन कंप्रोमाइज इवन जने ओटीएस कहले जने द लॉयर आर्ग्यूड दैट as if it is surface matter ओटीएस कर दे ओटीएस मु कोन करिवि you must read 125 that it is to prevent destitution and vagrancy and more so when you are pensioner
no subsequently already
भलो चाकरी करथले because of this habit चाकरी गला झगड़ा सब गला गोटे रूम रे रहउचंती कोरोना टाइम रे मु गोटे छोटो मोटो होटल बेले करिके किछि लोक खाइबे ताकू फोपड़ी देले से आसी नांती ताको व्यवहार साथ देखि नांती we have seen
what you are saying is correct at this age and after this much of time they should not fight but what can be done that is human nature is that they don't understand
sole dispute is after 2020 when wife in a said flat had started a catering business even though this is a residential house
catering corona time
kahi ki apun janchati
कोरोना टाइम ना खाइबा पई नै
आपण या कैटरिंग न करिथिले से सर्वाइव केमति करिवे
ना
फाइनेंशियल इंडिपेंडेंस
बिजनेस 3 to 4 persons lady
नहीं
was there and started business
for which I wrong information दी
इने सेटा आपण से एस्पेक्ट आपणकर काउंसलिंग तो एई परिबन
क्या आसिले नि काउंसलिंग भी आसिले नि
even specific
ताको व्यवहार कोर्ट रे भी हमें देखि जो स्टार्ट फेस करना भी
catering business as because it is a residential and the association has a demanding and try to realize the fine as because you have misutilized the so far as violated the agreement which is not meant for the commercial purposes and it is a residential one. To that respect, when I objected, then the dispute cropped up and come forward for 125. Till then, since marriage is returned.
With due respect to my honest senior has not gone through the 125 petition. That is one of the reasons.
Mr. Chakravarti is doing his best.
But no,
the best way to argue a matter without any merit is to say whatever comes to your mind.
Without filing any revision, without challenging the order, In my proceeding, my learned senior is arguing.
से catering business କଥା जो କହୁଛନ୍ତି that is improbable. ସେଟା improbable ଜିନିଷ ତା ସାଙ୍ଗରେ 125 ଟି ସମ୍ପର୍କ ନାହିଁ.
ସମ୍ପର୍କ ନାହିଁ.
And obviously ଆପଣ catering business ଆରମ୍ଭ କରିଦେଲେ ନା wife କଲେ?
ମୁଁ କଲି। ସିଏ ଆଜ୍ଞା ମୋ ହାତରୁ ଖାଇବେନି। ତାଙ୍କର ଇଏ ଭଲ କି ସିଏ ଭଲ। ମୋର ଏଣ୍ଟାୟାର କେସ୍ ହଉଛି ସେତିକି।
The petitioner herself started his catering business.
ସ୍ୱିଗି ଆରମ୍ଭ କରିଦିଅନ୍ତୁ।
ନାଇଁ ସେଟା କଣ ହେଲା କି?
ସ୍ୱିଗି ଆରମ୍ଭ କରନ୍ତୁ ଅନଲାଇନ ଡେଲିଭରି ଅଫ ଲିକର।
କ୍ୟାଟରିଂ ବିଜନେସ ସାର୍ ଯୋଉଟା କହୁଛନ୍ତି ସେଟା ନୁହେଁ। ଛୋଟ ଗୋଟେ ମୁଁ ଗ୍ୟାସରେ ସେଇ ଯୋଉ କରୋନାରେ କ୍ୱାର୍ଟରରେ ଯୋଉମାନେ ରହୁଥିଲେ ଫ୍ଲାଟରେ ସେମାନେ କହିଲେ ଯେ ମୁଁ ଯେହେତୁ ରୋଷେଇ କରେ ତୁ କରିକି ଦେ। ମୁଁ 5-7 ଜଣ ଲୋକଙ୍କୁ ଦଉଥିଲି। ସିଏ ଆସିକି ରାଗିକି ଫୋପାଡ଼ି ଦେଲେ ଗ୍ୟାସ ଫ୍ୟାସ ଫୋପାଡ଼ି ଦେଲେ ସବୁ ଚାଲ ତାରି ଉପରେ। ସେ ବହୁତ ପରର କଥା ତା ଆଗରୁ ବହୁତ ଷ୍ଟୋରି ଅଛି। ବିଦେଶ ଯାଇଛନ୍ତି ସେ ଚାକିରି ଯାଇଛି ତାଙ୍କର ଏଇ ଗୁଣ ପାଇଁ। ତା ଛଡ଼ା ଏତେ ସମୟ
counsel for the petitioner, the learned counsel for the petitioner as well as the learned counsel for the opposite party were had at length. The determination, the issue that falls for determination in this present application is of very level, is no more res integra, as has been authoritatively pronounced by the Honorable Apex Court in Rajneesh versus Neha, that the direction for payment of maintenance under section 125 of CRPC shall be from the date of application. Accordingly, stop. The Learned Judge Family Court in its judgment dated 31/7/2025 in criminal proceeding number 159 of 2020, filed by the wife in the marriage, the husband in the marriage being the opposite party, has directed for payment of maintenance from the date of order. The said order starts modified to the extent that the amount of maintenance per month shall be from the date of application. So the petition is disposed of accordingly. Before parting with the matter, this court takes note of the concern of the learned counsel for the petitioner as well as the opposite party, that considering the age of the petitioner as well as the opposite party, both being senior citizens, the particular the opposite party being a senior citizen and the petitioner being Lakshmi Narayana. Usarani being the wife being aged more than 55 years and the husband being more than 60 years. Good sense should prevail between the parties to end their the bitterness in the relationship. Hopefully, better sense will prevail. The parties shall lead a peaceful life. With the said hope, the matter is disposed of.
Item number 26.
Mr. Raut, in Rajneesh versus Neha, Supreme Court has followed Odisha High Court. Because Odisha High Court, there is a chain of decisions. It has to be from the date of application. There is. So they have followed and made it 141. Now it is the law of the land. But they have followed Odisha High Court.
Exactly. But so far as the Rajneesh Neha is concerned also, there is no question of so far as in 125 proceeding, the evidence of the cross-examination of the witness will be expunged. But there was there. But we have not
That is Rajneesh versus Neha because it is procedural.
May I please allow you?
Yes.
Let's see, item 26, we have filed the notice today only.
Your name, madam?
S. Subhadarshini.
Miss S. Subhadarshini. Mr. Manas Kumar Chand along with Mr. S. Subhadarshini for the petitioner. Opposite party blank. It is submitted by the learned counsel for the petitioner that due to inadvertence, the requisites for issuance of notice could not be filed. And the same is filed today.
That's it.
The requisites filed shall be accepted, fixing a fresh returnable date. Accepted, stop. Fixing returnable date afresh, notice be issued to the opposite party as directed by order dated. Notice order. Yes, next.
Okay.
27.
So Narayan Prasad Parija for the petitioner.
Twenty-seven.
Last time, the amount that he had received, which had already been divorce. After divorce, she has filed one petition under 125. My only question, that once the divorce has been allowed and the money is back, there is no scope for 125.
No, that's a wrong proposition of law. Check CRPC. CRPC is very explicit that the divorced wife can file. 125 can be filed by a divorced wife. Your argument can be that she has been paid permanent alimony. But upon the question she cannot file, seta thale mo order ta bhul hejibo.
Permanent alimony ta deiki au se receive karibe.
Apanakara divorced wife pai paribo.
Divorce ହେଇଥିଲା ଟଙ୍କାଟା ଦିଆ ହେଇଥିଲା ସେ 125 ହେଇଗଲା ତାପରେ ଟଙ୍କାଟା ଦେଇଗଲା ପରମାନେଣ୍ଟ ଆଲିମେଣ୍ଟ
डिसीजन भूल डिसीजन या स्टैट्यूट को केमती डिसीजन अल्टर कर दबो पार्लियामेंट करिवो ना मु कोने बे कहबी जे आपण जोटा क्वेश्चन इट इज लॉजिकल मे बी बट द डिवोर्स्ड वाइफ हैज ए राइट
he has a right but once the divorce has been completed that is not his claim on one level. And I have filed the receipt.
सर को दियो बोइटा
Eh?
बोइटा सर दियो और सीआरपीसी को रहला और ठीक है जेटे सर देखो one B small b
Divorce one can file the matter.
can you just read that?
Then you know.
One per pile 125 sir pro explanation B. The wife includes a woman who has been divorced by or has obtained a divorce from her husband and has not remarried. So if I pass the order, what you are arguing, my order goes. इथे कोण नोटीस आहे नी
No, notice है कि after पुनः.
Okay.
फिर after पुनः.
Interim order है नी कुछ.
नहीं interim order है खाली पेटा मो पेटा पट्टी बनी हुई.
आता अच्छी तो कोण
नहीं खाली ये दी मास में हिसाब 18 माइनर
नहीं सेटा तो आपण कहिथिले मने जे से एक्चुअली डिपॉजिट करि नथिला.
नहीं कोई नहीं.
Condition एबे कले. Last time you said that since the husband did not comply the condition by the this court रे आपण पैसा टा दियंतु बोली से तबळे
नहीं मुझे रसीद दे. I find.
Yes, I have marked that.
The
The learned, hard learned counsel for the petitioner appears like it's so Narayan Prasad Parija for the petitioner. Opposite party blank. Pursuant to the notices issued by this court by order dated, keep notice issue by order dated 28/2026. And the notice having been sufficient. देखी देवे sufficient डेटी बाजी साहब देखी देवे लागू sufficient बोल तो लिखा है notice having been sufficient no one appears for the opposite party. Stop. The learned counsel for the petitioner refers to the order dated 28/1/2026. Paragraph 4, which is reproduced here. He then refers to the order dated 20/5/2026, wherein The order passed by the learned judge, learned senior civil judge Kamakhya Nagar in CS into bracket MAT number 27 of 2018. Order जो लिखे नहीं, order passed by. So order date टा बगल. Order dated 8/5/2024 passed by the so and so. That the opposite party has received the original DD. Demand draft, full republic on the demand draft bearing number 081053 of State Bank of India, Kamakhya Nagar. Accordingly, it is submitted that by the learned counsel for the petitioner. Accordingly, it is submitted by Mr. Parija that entire amount of rupees 5,20,000 has been received, issued by the opposite party. Stop. Para. Para. IATA pending ଅଛି?
Limitation.
IA just 40 limitation. IA 439 of 2025. Hard learned counsel for the petitioner, he reiterates his submissions as noted above. In view of the receipt of the amount of alimony by the opposite party wife in the marriage, the order, the impugned order dated the impugned order passed dated 20/1/20 passed by the learned senior civil judge Kamakhya Nagar. I should place it in. Further 125 order ta kete page again? 125 रे को page रे order ta
125
3. The petition लिखा है 2 तमरो 3 को 2 लिखा है नेक्स्ट the petition टा 2 टा order टा कहीं
3 रे लिखा है कि under section रे
15 the copy of the petition लिखा है
15 रे 21 पेज
order dated dash passed in CRP 159 of 2022. So order टा को page रे ଅଛି sir?
मेरे part page 22.
It's 22. The operative portion of the judgment dated 19/3/2025 in CR.P. number 159 of 2022, directing deduction of amount of rupees 25,000 per month. 7,000 per month. 7,000 per month from the salary of the from the petitioner husband shall not be given effect to. The matter shall be awaiting appearance of the opposite party. The matter shall be listed for orders in the week commencing 3/8. देखिए अपन परसुएट करंतु काउंसिल को कहि कि जैसे अपियर करंतु अपन तो लोकल काउंसिल जे थिबे कहले तांको काउंसिल को कहबे सो दैट दिस मैटर कैन प्रोसीड. Difficult, but this is a thought that came to my mind.
As a wife, she claimed the matter. It was accepted that he become a
Sir, explanation B to 125 1 is very clear.
I'm
Even it says, even the wife files application and gets divorced, still she can claim maintenance.
he can, and she can claim maintenance as a divorce wife, not as wife. That is what.
Seta kariyo 125 re kariyo. Because it's an inclusive definition. Wife, because the framework has taken care of that. For the purposes of this section, wife includes divorced wife, whether she has obtained divorce or has been granted divorce.
I have not on that part. I have one part. Whether he has applied as a divorce wife or wife. If she has applied for wife.
Then Mr. Parija, when after the divorce is granted in a pending 13-1 application, 125 has to be dismissed. That cannot be. There is a possibility that in appeal the 13-1 judgment is set aside. That cannot. So that is the legislature has taken care of that.
Item number 28.
Item 28.
Yes.
We have a Mr. Parida, my lord, kindly 2 weeks after. He
Hello,
is
sir, I
out
have
of station.
objection,
my
my
lord.
I am appearing for the opposite party, my lords. The last 4 occasions, my lords, may see they are taking time.
Execution pending stage.
My lords, there is it has the executing court has ordered for attachment of his salary, my lords. My lords, now showing this pendency of this revision, my lords, is not participating.
Okay. What's your name, sir?
Pramod Kumar Sahoo, my lord.
Mr. P.K. Sahoo on behalf of.
Subhendu Parida.
No, I remember, but I just forgot. Mr. P.K. Sahoo on behalf of Subhendu Kumar Parida for the petitioner. You are Mr. Das.
My lords.
Mr. Gaurav Das for the opposite party. The adjournment is sought for by the learned counsel for the petitioner when the matter is taken up for orders. The matter is kept pending before these courts. After it was taken up for orders of 5/12/2025. Thereafter, it was adjourned on 10/3/2026, 4/5/2026. Apparently, the effort of the petitioner is to seek repeated adjournments without any plausible reason
Out of station.
for the last over 7 months. For the last 7 months. Stop. Today there is no cause and reason to grant any further adjournment. Stop. It is submitted by the Lord Counsel for the petitioner that the the matter pending for execution before the Learned Judge Family Court Kendrapada is not proceeding due to pendency of the present application. The Learned Judge Family Court Kendrapada shall proceed with the execution. Copy of this order shall be communicated to the Learned Judge Family Court Kendrapada by the registry. The adjournment sought for by the petitioner is granted reluctantly. The matter shall be listed for orders in the week commencing 27/7/2026. Okay.
Item number 29.
In accordance with law. Setby move takar illness ground adjournment needs from Mr. Mishra. Particular court ko asibe hatat kahi ki arambha karibe. Don't become the jack out of the box. Try to inquire kon hela ote matter thila. That's the usual we do. The matter kon heito ki nale ti apaya kare pacharibe. Nai pass over ni.
May I please, your lordship?
Mrs. Saraswati Senapati for the petitioner. Yes, Mrs. Senapati, please.
Lordship. The petitioner is challenging the impugned order, my lord, where her application under 124 BNSS has been rejected by the learned family judge Bhadrak.
On the ground?
The ground that she has not proved the income assets of the opposite party number 1, her husband, and she is getting maintenance under DV proceeding. But actually she has not received the award.
DV re apon jota paibe. The mandate of law is now that it has to be taken note of by the court. Bhul kon hela?
So there is no but under DV proceeding she is getting the maintenance and she will be denied to get the maintenance.
Kete claim kartile?
10,000 sir.
10,000. DV re kete pauchonti?
The DV re 2,000 award heitla but she is not getting the award.
Seita te alga jincha. Jeta execution file karibe. But apno husband karanti kon dekheile?
Sir, she has opposite party 1 has agricultural land in which he loans to
lakhs 50,000, and in her affidavit she has stated, but the learned court has not considered in judgment.
But it was hard that day. That length. ଆପଣ ଇସ୍ୟୁରୁ ପଢନ୍ତୁ paragraph 4.
Whether the petitioners are
But the
unable
mother
to maintain themselves.
The mother answer.
Yes, Lordship. In Exhibit 3 and 4, my lord, she has exhibited ROR, which indicates he has the landed property, my lord, and he denies to maintain.
Para 8 ପଢନ୍ତୁ.
This court finds that Lordship, para 824.
Yes.
Yes. This court finds the present case to be peculiar in several respects. Petitioner number 2 has not stepped into the witness box to substantiate the pleadings made on his behalf. Not a single scrap of documentary evidence has been produced to show the petitioner number 2 is physically handicapped or that he is incapable of earning his livelihood. On the contrary, the materials on record reveal that petitioner number 2 is a young man aged about 22 years. In absence of any cogent proof, this court finds it difficult to accept the bold assertion that petitioner number 2 is handicapped to such an extent that he is unable to maintain himself. It is further observed that petitioner number 1 has prayed for award of maintenance from her husband as well as from her son simultaneously. Likewise, petitioner number 2 has sought maintenance from his father and brother. Admittedly, all 3 children of petitioner number 1 and OP number 1 are majors, and as per the admission of petitioner number 1, her daughter is already married. This court is constrained to consider how the marriage expenses of the daughter of petitioner number 1 were borne, as no explanation has been furnished in this regard, thereby creating doubt about the financial incapacity pleaded by the petitioners. The petitioners have also failed to establish the income and financial status of the OP number 1. The disclosure affidavit of assets and liabilities filed on behalf of the petitioners has been prepared in a cryptic manner and doesn't conform to the format mandated in Dodgeness versus Neha and others. The probative value of such an affidavit is therefore minimal. The petitioner number 1 has admitted in a deposition that the learned court of JMFC in a proceeding under the Protection of Women from Domestic Violence Act has already directed OP number 1 to pay rupees 2,000 towards house rent. Her own admission further reveals that OP number 1 is not complying with the said order. However, no effort has been demonstrated by the petitioners to execute the said order through the appropriate legal mechanism. In these circumstances, both petitioner number 1 and petitioner number 2 have failed to prove that despite having sufficient means, OP number 1 has willfully neglected and refused to maintain them. No supporting documents.
Nothing. Brother against the maintainable happened.
Sir, why to
ଆପଣ 27 ବର୍ଷ ଆପଣ ଯଦି ହ୍ୟାଣ୍ଡିକ୍ୟାପ୍ ତାଙ୍କୁ ହେଲାଣି ବୟସ 60-62 ବର୍ଷ ହେଲାଣି ତାଙ୍କଠୁ ଆପଣ ନେବେ ଇଏ ଆଉ ଆପଣ ଯୋଉ 2000 ଟଙ୍କା ପାଉଛନ୍ତି ପାଇବେ ସେଟା କଣ ହବ ସେଟା ତ ଅଲଗା କଥା.
sir, maintenance
Take a note of.
Lordship, so maintenance, the learned trial court, no supporting documents has been filed to establish the ending of opposite party.
ଆପଣ ଗୋଟେ 60-62 ଲୋକଟାକୁ ଆପଣ କହିବେ ଯେ ପୁଅ ମୁଁ କାମ କରିବିନି ମୁଁ ଫିଜିକାଲି ହ୍ୟାଣ୍ଡିକ୍ୟାପ୍ ଆପଣ କିଛି ଏଭିଡେନ୍ସ ଦେବେନି.
No, sir, in your evidence, he has stated. No, sir, she has stated in her evidence. Let's say, kindly listen.
Go by the judgment. As you know, I am.
Let's say she has stated her income, his income.
I have very aversion to go beyond the records. I have some understanding of law, which because I cannot go beyond records. I may be impressed with your pleadings or argument, but you must go by the records.
No, let's see. See, sir.
Nothing. Upon your point, has the court not considered that? Court has considered that.
No,
it was your duty to prove the evidence of that person who is now 62 years of age.
Sir,
If you are-
62 will sir wife desertion ने अच्छी sir से केमते maintain करिवो तो wife को किछ तो sir से
Yeah, ଆପଣ ଯଦି ତାକୁ prove କରିବେ
2000 sir insufficient ଏବେ ବର୍ଷେ
ପ୍ରୋବ୍ଲେମ ହଉଛି ଯେ ଆଉ ଗୋଟେ ପ୍ରୋବ୍ଲେମ ହଉଛି ଆପଣ ଯଦି ଗୋଟେ 37 ବର୍ଷର ଲୋକ ଏବଲ୍ ବଡିଡ୍ 62 ବର୍ଷର ଲୋକଟା ଏଜେଡ୍ ଫାଦର then जो logic that a able-bodied person should work as a, even as a daily wager or have some daily earning to maintain his father or mother, can it be reversed?
So, sir, at least consideration of wife is
Argument is the father will work as a daily wager and maintain the son.
no lordship तो wife तो at least wife
परंतु आपणकर you are not thinking also. Then what is the difference what the person has told you and what you as a lawyer what you will understand? आपणकर 125 एटा application था.
yes
125 रे there is sufficient provision. 125 रे change circumstances रे provision अछि. So seta kotha how this court will adjudicate now as a divisional court will adjudicate all these things. The most difficult proposition you are propounding that the father is 62 years of age will work and fetch for his wife and the son.
also the court at least consideration regarding the maintenance of wife
It has.
no, sir, she's not getting
Because otherwise your argument would be in air. So that is how I tried
no
to make
sir
go through the
no lordship
finding
she's
of the
not
child.
getting that award and that award also be insufficient lordship
That's a
2000
different thing. That is ଆପଣ ସେଟାକୁ ଆଗ ଆପଣଙ୍କର ସେଟାକୁ ଆଗ enforce କରନ୍ତୁ 2000 ଟଙ୍କା ପାଆନ୍ତୁ ସେ ପଇସା ଖର୍ଚ୍ଚ କରି ଆଉ ଥରେ କେସ୍ ଲଢିବେ when
as per instruction lordship she has filed recently the execution
ଯାହା କରିବେ ତାହା ବୁଝିବେ ସେଟା କଣ hard ordered counsel for the petitioner. And that is the reason they are also not engaging a lawyer. Because they want everything free. ଘରେ ବସିବେ ବାପା କାମ କରିବେ ଓକିଲ ଦେବେନି otherwise case material ଥିଲେ you are good enough lawyer to ମାନେ argue but ଏଥିରେ କିଛି ନାହିଁ ଏ case ରେ legal aid ତାପରେ ନେବେ it is something like if you go nowadays there is a lot of rush in hospitals. One reason they are saying that since everything is free, everyone is going to hospital for getting some examination. More attack kar diyantu, more seta kar diyantu. Nobody is awaiting for prescription. Ye avastha se aichi. The London Council for London Ms. Saraswati Senapati for the petitioner. The London Council has been engaged by the High Court Legal Services Authority to argue the matter. He argues with a lot of effort and vehemence to challenge the judgment dated 10/12/2025. Having heard the London Council for the petitioner, yes, having heard the London Council for the petitioner and considering the material on record, it has to be observed that the London Judge Family Court has passed the order in the application filed by the petitioners under section 125 of CRPC. After considering all the materials on record and considering the propositions of law. Stop. Paragraph 8 of the judgment under challenge in revision is reproduced here. Stop. Para 8 and 9 करते हो, This court finds no illegality or infirmity in the judgment passed by the London Judge Family Court, Bhadra. The appeal is dismissed accordingly. Next.
Item number 30.
May I please, Your Lordship?
Yes, please. Your name, sir? You are Mr. Mahapatra?
A.B. Malik.
Mr. A.B. Malik.
Your Lordship.
AP your full form.
Ambika Vallabh Malik.
Mr. Ambika Vallabh Malik for the petitioner. Opposite party, Mr. Right. Again, 30 ରେ ଆପଣ? So Naik for the additional standing counsel for the opposite party. ଆପଣ ଏଟା time period extension କଣ ଚାହୁଁଛନ୍ତି sir?
My only submission for the
Copy ଟା serve କରିଛନ୍ତି ନା ନାହିଁ ଆଗ? ସିଏ ମତେ ଅନଉଛନ୍ତି ଆପଣ ଅନଉଛନ୍ତି
copy serve करना है lordship.
ये की କଥା ଆଜ୍ଞା? The IN लिखिବେ IA 117650 of 2026. The IA has been filed for extension of time in the disposed of application time.
Your lordship,
In the
disposed
disposed of application, in the disposed of writ application is comma disposed of by order dated 2/6/2026. Copy of the IA shall be served on the learned AC. Kali bhitere debe
Your lordship,
by tomorrow. The matter shall be listed for orders in the week commencing 27
sir, आपके कमिले भलो होता.
अरे भलो हबो जे आपण तो कम्प्लाई करू नांती आपण जो which order टा कम्प्लाई करथिले भलाई न थांते कि
Sir, मु
extension file न कर जदी
sir comply करछि which is pending before the sub collector puri. मु comply करी file करछि which is pending before the sub collector puri.
ताले एडा आणंतु 27 आज केते नहीं
Sir, sir
6/7 week commencing 6/7
lordship, sir.
ठीक है दियन कॉपी दियन
Lordship, copy.
yes next please
Obliged.
after notice matters I will not open the briefs right now. A lot of matters have been passed over somehow. It so happened when about that 15 टाका pass over he reached. So I have to take up those matters also.
My lord, what is to be done because one of them has he, my lord, superannuated last yesterday only. My lord, they are working for the more than 30 years. And they are entitled to be regularized in view of their own documents. So your lordship may kindly.
No, it has to be. I understand the urgency. You are saying that there is an urgency. And the matter is kept pending for the last 8 years. You take a date.
That's what I am suggesting.
You got to get for you.
Mane gote date karantu fresh admission asu so that.
Aji orders ପାଇଁ କହୁଥିଲେ ମନା କଲି ମିଷ୍ଟର ପୁଷ୍ଟିକା yes he is sitting so ସେଇଟା କରନ୍ତୁନି ସେମିତି ହେଲେ ମ୍ୟାନେଜ କରି ହବନି
ସେଟା ମୁଁ ବୁଝୁଛି ଆପଣଙ୍କ
କିନ୍ତୁ ଏଠିରେ ଫ୍ରେଶ ଆଡମିସନ ବି ହିୟରିଂ ହବାକୁ ପଡିବ
ଆପଣଙ୍କର କଥାଟା ବି ଆମେ ବି ବୁଝି ପାରୁଛୁ କିନ୍ତୁ ଆମେ ବି
since it is a 2018 matter এটা ଉପରେ ହିଁ ରହିବ at least computer recognizes that ସେଥିପାଇଁ ସେଟା ଟପ ରେ ଅଛି ଆପଣଙ୍କ actually it is in the top of the hearing list possibly ଆଜି ବି ହେଇପାରେ ଦେଖିବା କଣ ହଉଛି ଆଜି ଆପଣ ତ ସେ ବହୁତ ଗୁଡେ ପାସୱାର୍ଡ ମ୍ୟାଟର ସରୁ ସରୁ ଟିକେ ସମୟ ଲାଗିବ
ଚାଲୁ ତାହେଲେ ମୁଁ ମୋର ଅନ୍ୟ କାମ
ଆଜ୍ଞା ଆଜ୍ଞା ପ୍ଲିଜ ସୋ ଏଟା ଗୋଟେ ଡେଟ୍ କରନ୍ତୁ
ମାନେ ତମ ରିଜେଣ୍ଡର କପି ଦିଆଯାଇଛି କେତେଥର ଦିଆହବ
ସେଇଟା ରିକ୍ୱେଷ୍ଟ କଲେ କଣ ଦେଇଦେବେନି
ଦେଇଦ
ବିଶେଷ ପଣ୍ଡା ସର୍ଭେ କପି ସେଇଟା କଣ କରିଦେବେ
ଆଉ ଗୋଟେ ଅଛି ବୋଧେ
ହେଲା ଆଉ ଗୋଟେ ଦେଇଦେବି କଣ
କେତେ ନବ କପି ନେଇକି
31 ଟାକୁ ଆପଣ ୱିକ୍ କମେଣ୍ଟିଂ 27/7
27 ନା ଏତେ ଡେରି କର ଆଉ ଟିକେ
there is a purpose 6/7/133 13/7 134 20/7 121 so up to 20/7 there are specifically urgent matters are 400
ମୁଁ ସେଟା ବୁଝୁଛି
so
ଆପଣ
that
ମାନେ
is how
ପ୍ରୋବ୍ଲେମ ଆମେ
it has to be no because listing is not a problem so I matter
no listing is not a problem but
audio important hearing time important
that
so that is there is a purpose in there is a method being adopted and obviously memos will be added jaha memo file hobo to fer add hobo na list re these are already
ଆପଣ ମାନେ ହାର୍ଡ ପ୍ରେସ୍ କରିକି ଆମେ ବୁଝୁଛୁ ଆମେ ମାନେ ବି ହାର୍ଡ
no
ପ୍ରେସ୍
definitely you have difficulty to answer I'm the answer debuni to client you will be answer we commenting 27/7 rakho ଯଦି କହିବେ 27 ରହିବ it is well that is how I purposefully give you the numbers if you want 27 ରେ ସୁକଣ ଅଛି
ହଁ 27 ରେ
commenting 27 कर दियो
ୱିକ୍ କମେନ୍ସିଂ କାଇଁ କରୁଛନ୍ତି
ସେଟା ନହେଲେ impossible to manage ଆପଣଙ୍କର ଯେତିକି ଗୋଟେ ୱିକ୍ ରେ ଲେଫ୍ଟ ଓଭର ରହିବ କି ଧରନ୍ତୁ କିଛି ମ୍ୟାଟର କାଲି ଆଜି ସରିଗଲା କାଲି କି ଆପଣ ମ୍ୟାଟର ଆଡ୍ କରିଦେଲେ ତାতে ଆପଣ ଜୁଡିସିଆଲ ଅର୍ଡର ଥରେ ଫିକ୍ସ କରିଦେଲେ ଦେୟାର ହ୍ୟାଣ୍ଡସ୍ ଆର୍ ଟାଇଡ୍ କୋର୍ଟ ମାଷ୍ଟର କ୍ୟାନଟ୍ ଡୁ ଏନିଥିଙ୍ଗ
ମୁଁ କହିବା କଥା ନୁହେଁ କହୁଛି ଜୁଡିସିଆଲ ଅର୍ଡର ହାଜ ବିନ୍ ପାସ୍ ଇଟ୍ ଇଜ ନଟ୍ ବିଂ ଲିଷ୍ଟେଡ୍ ସେମାନେ ଆପଣ ମାନେ ସିଟିଂ ଓଭର ୟୁର ଲର୍ଡସିପ୍ ଅର୍ଡର
ସେଇଟା ଆପଣଙ୍କର ଯଦି ସେଟା ବି ହଉଛି ପ୍ଲିଜ ଫାଇଲ ଏ ମେମୋ ରିକ୍ୱେଷ୍ଟେଡ ଟୁ ଫାଇଲ ଏ ମେମୋ ଯୋଉ ଦିନ ଯାହା ପୋଷ୍ଟିଂ ହେଇଥିବ बेले बेले आगे ट्रैक रखियो भी कष्ट होछ तरंतु ए वीक रे गोटे किछिटा मैटर रही गला बिकॉज़ ऑफ आई एम नॉट अवेलेबल और समथिंग हला छुट्टी हला कि एडजस्टेड हॉलिडे हला सेटा तो पाइल ऑफ हला देन द मैटर इज लॉस्ट ट्रैक ऑफ कि बॉडी गला जो मैटर तो आपण मेमो दे दियो ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ମେ ବି ପସିବଲ ଇଣ୍ଟେନସନାଲି ହଉ କି ମୁଁ କହିପାରିବିନି
ଆଜ୍ଞା ହଉଛି
but please don't attribute any motive or intention
ନାଇଁ ନାଇଁ
ଗୋଟେ memo ଟେ ଦିଅନ୍ତୁ
ଆଜ୍ଞା ଆଜ୍ଞା
no I cannot say the Hon'Ble that obviously I cannot say. So after notice matters I'll continue after completing of the submission orders
if possible today if not 20th
ନାଇଁ ମୁଁ ଆଜି ନେବିନି
ଆଚ୍ଛା
there's some I mean hard
then
days.
then it's all no problem oblige
Sir 35 डेट कर देला हो तो ठीक कर दो 35 डेट कर दो anyone seeking any date can talk to Mr. Maji he will give you a date after notice से जार जदी others both side अछंती Mr. Mishra का मैटर रे एक्चुअली other side appear करी ना
My lord,
state अच्छी पर
my lord,
yes Mr. Naik 35 कोटे डेट हो
my lord, sorry, item 11 due
आया
to
टिके चांस दियंतु बट कहाला जे पास ओवर हेछि तो मु सिर्फ just now I discussed with
Miller item 33 का adjourn.
33 the objection, seriously objection. I am the petition Miller. Your lordship, 3 months they have taken time. Your lordship, I
Mr. Ratha is objecting upon the rule.
object.
All agree करंतु गोटे
Say fake.
you आपण you accommodate Mr. Ratha's request then you mention or सेमती करंतु
सर ठानेपुर मु आपन पाखर अछि फेक सर्टिफिकेट दे कि चाकरी करी दरमाटा तो बंद कर दे ओटे
आज्ञा ठीक है आपण के मेरिट आर्गुमेंट करछन से तो कहउछन आपण कहले
फेक सर्टिफिकेट चाकरी कले मते बाहर
होछंती डेट नियंतो नले अपेक्षा
Miller date.
let us not spend time on like this
Kindly give me a date, Miller.
से डेट सर
से पर कहिले आपण जे से कसो आर्ग्यू करे चाहुना एडजमेंट फिर आपण को काइंड डेट परे देखिबे न मिस्टर मिश्रा का 35 को डेट कर यू सजेस्ट a date 27 ना 38
ଏଟା ଗୋଟେ ଜମି ବିକ୍ରି କରିବାକୁ ପରମିଶନ ଟା ରିଫ୍ୟୁଜ ହେଇଛି
सर 27 आज आई टोल्ड यू 27 पर 400 मैटर अछि 27 कोन देखा 27 रे 77 रे 77 अछि सो
सर ଆଉ ଗୋଟେ ତା ପରବର୍ତ୍ତୀ ଅଛି ଯୋଉ ଦିନ
27
27
27 7 में
ଆଜ୍ଞା
My lord, item 36.
yes what do you want
I am for the opposite party seeking for time to next
petitioner को कोई 27 रे मिस्टर महंत मेंशन करना 36 टा
36 रे फर्स्ट आवर आर्डर मागुतले जे उभय पक्ष नथले ବୋଲି सेटा
सेटा ताको प्रेजेंस रे कोंतु like Mr. you are saw Mr. Ratha objecting to the adjournment simply say करि पारंतु let us see
तेतीसटा मिस्टर रथ फोन करथिले आउट ऑफ स्टेशन अछंती
और डेट दियंतु
ना मोर प्रया था एटा डिस्पोज होइबो मु पेशा कोइ जो मिसकेसटा अर्ली डिस्पोजल से मिसकेसटा डिस्पोज करी गवर्नमेंट को इंस्ट्रक्शन मागे टिके नोट काइंडली ये मिसकेस 5397
ठीक है चालू
एटा डिस्पोज
लेट आउट ऑफ टर्न तो नहीं होगा ना लेट द लिस्ट कंटिन्यू
एटा हमर डिस्पोजल हो जाता ओटा डेट होता से 27 रखंदे आ कोन
आगे
से 27 आपण जा कोतर करसे
27 टा आसु पूरा सब से दिन जा कहियो होला सिंपली अर्जन कर केते आइटम सर मिस्टर रथ
हम को जे गोटे जुडिशियल ऑर्डर हेले आई लुक हैप्पी एंड क्लाइंट
जा भी होची जुडिशियल नॉन जुडिशियल
नहीं ई ऑर्डरटा हेले
नाम पेपर की जुडिशियल नॉन जुडिशियल
अर्जन हेबाटा आप क्या इटा लिखिन रेगुलर हे जान गवर्नमेंट भी इंस्ट्रक्शन दे जो ओवर टाइम नाउ फिर एडिशनल एफिडेविट
32 आइटम टा आपनकर
एडिशनल एफिडेविट गवर्नमेंट इंस्ट्रक्शन
32 से दिन आसीबो 27 दिन
से इंस्ट्रक्शन नै गेले ऑर्डरटा हेले भलो होते प्रेयर कोच
अरे से इंस्ट्रक्शन नेबेनी बोल किन भावचों आपण 22 मसिया मैटर
दीटा मैटर बा नै नाती दीटा खाली मु प्रेयर कोच के काइंडली टिके से ऑर्डरटा हेले से इंस्ट्रक्शन नै जान फिर से आगुडे डेट नै
आउट ऑफ टर्न नै परियो
आज्ञा
अरे आपण ताको रिक्वेस्ट करो
हम लिखि दे ताको नोटिंग कर दी 10 को नोटिंग कर दी
ठीक अछि
ए मिसकेसटा डिस्पोजल
आउट ऑफ टर्न ऑर्डर करियो Or call for the list.
Shall I wait
Pass over item number.
shall I wait till the list?
No, no, no.
Tell 27 ki rahila.
Ah,
Okay.
what say computer record देवे?
Okay. Yeah.
Item.
Pass over item number 5.
Non-affairs for the Mr. Mahapatra. Udananda Mahapatra for the petitioner. Good. Yes. Yes. ठीक अछि. So Udananda Mahapatra for the petitioner. आपण का नाम है? Mr. K. M. Hathi, Petramon Hathi, along with Mr. Suryakanta Dibedi for the opposite party. The learned counsel for the petitioner, opposite party submits that he has filed Wakalatnama. Mr. S.K. Dwivedi has filed Wakalatnama. Mr. S.K. Dwivedi and learned associates have filed Wakalatnama. They may be provided with a copy of the petition. Copy of the petition shall be served within 2 working days.
Okay.
2 working days. The matter shall be listed for fresh admission in the week commencing. So Mahapatra kebe anle hobo?
We commencing 22nd.
20 साथ.
Only one prayer, my lord, may I make. In fact, the application, a civil proceeding under section 13 of the Hindu Marriage Act was filed by the petitioner, the husband. But if there will be any endeavor for a settlement or mediation,
I can become a mediator. ଆପଣ କରୁନାହାନ୍ତି? Sir, you are most well equipped, sir. Sir, କହୁଛନ୍ତି mediation ପାଇଁ ଚେଷ୍ଟା କରନ୍ତୁ. ହେଲା? ଆପଣ କଥା ହଉନ୍ତୁ Mr. Dwivediଙ୍କ ସାଙ୍ଗରେ. You just intimate apprise him that Mr. Mahapatra is saying regarding if it can be. And it is always good that when matrimonial matters, if you arrive at any kind of settlement. ହେଲା? Trial family court रे आज्ञा counseling अछि. There is a lot of confusion. Family court रे counselor अछंती. Family court counselor act भी अछि. It is mandatory. सेटा भी कहंतु.
No, why I am saying, my lord, I am told that conciliation was actually made in family court in the intervention of learned family judge.
It has to be. That is statutory.
It was made. It was made. What has told me? What has happened? Wife was agreeable to come. Husband was also agreeable to take. But due to badly interference of the father of the actually opposite party, everything was failed. But instruction I have gathered. Therefore,
now father of the opposite party is not a party.
Not a party.
He goes unrepresented. So let us not discuss about him.
কিন্তু ସେ interfere କଲେ
ସେଇଟା interference the party କରିବେ ତାହେଲେ
ନା ନା ସେ କଥା ନାହିଁ ସେଥିପାଇଁ କହୁଛୁ ଫର୍ଦର ମିଡିଏସନ ହେଇପାରିବ ଯଦି ଫର୍ଦର ମିଡିଏସନ ହେଇପାରିବ ବେଟର ହବ
mediation is not possible in matrimonial matter. It is already mediation. ଆମର ଯେତିକି mediation overburden ହେଇଗଲା. Family court we cannot substitute. We do not have counselor also. Family court professional counselor रखिबारे there is a purpose. We are selecting counselors for that purpose only. Because matrimonial counseling is something different.
And many cases mediators of our High Court may not are doing.
That is how there is a percentage of success in matrimonial mediation is very less in High Court.
30-40% yours.
That was a बहुत बड़ा achievement. 30-40% is बहुत बड़ा achievement. देखो
Item 8.
Petitioner none, opposite party Mr. Prem Kumar Mahathi, Additional Standing Counsel, none appears for the petitioner, though the matter is called twice over. To grant further opportunity, the matter shall be listed for fresh admission in the week commencing 27/7/2026.
9.
Petitioner none, opposite party blank, same order. Once when it reached and thereafter, again after resumption of the proceeding, post lunch. Yes. We commencing सबड़ा 27 कर दो. 3-8.
11.
Ramesh Chandra Raut for the petitioner. Mr. Amarendra Prasad copy टा देली क्या पड़ो?
Yes, ma'am.
कोई दिन देली.
We have received a copy today.
कौन किसी instruction नहीं पारी वो कौन?
There is
quorum
available to the petitioner. He has disputed the demand of quantum of contribution.
and liability. Sufficient opportunity have been given before passing of the order. As they did not deposit nor file any appeal, the authorized officer has to issue C-19 requisition, certificate requisition. Thereafter, the coercive action was taken. That was not appeal. That cannot be treated as
ନା ଆପଣ appeal ଦେଲେ କଣ ହବ?
appeal period ଅଛି.
ଆମର ଯେମିତି ଗୋଟେ ଅଛି ଡକ୍ଟର ଆରେ ଆପଣ ଟିକେ ଅନେଇଲେ ସିନା ହବ ତାକୁ ମତ ନେଲେ କଣ ହବ? ଆପଣ appeal ଟା କାହିଁ ସେଟା? ଆରେ appeal ଟା କାହିଁ? ପଢିଲେ ପଢେ ମା ଶକ୍ତି ଫେବ୍ରିକେଟର ଇଜ ଦ appeal. ସେମିତି କରନ୍ତୁ. ଆପଣ ଲୟର ହେଲେ କେମିତି ଆପଣ ଚିଠି ଲେଖିବେ, ଚିଠି କହିବେ appeal. ଆପଣ ଲେଟର ହେଡରେ ଫେର ଚିଠି ଲେଖିଛନ୍ତି. ବଟ୍ appeal ମଧ୍ୟ ଟାଇମ ବାଡେଇଗଲାନି.
Statutory appeal time ବାଡେ. ସେଇ ଅର୍ଡରଟାରେ ହିଁ ଅଛି ପେଜ 16 ରେ ମାନ.
ବଟ୍ ଆପଣଙ୍କର appeal ରେ ମୁଁ ଡିଲେଟା କଣ୍ଡୋନ କରି ଯୋଉ ଅର୍ଡର କରିଥିଲି ଏଟା ହେଇପାରିବ?
ଏଇଟା ହେଲାଣି 23 ମସିହାର 24 ମସିହାର ଅର୍ଡରଟା. 24 ମସିହାର ଅର୍ଡରଟା coercive action already taken. Any prayer can be made before the appropriate forum, my lord.
What appellate forum?
Yes, appellate forum, that means the Employees Insurance Court under section 75 of the Act. Besides, there is a decision 1997 1 SCC 625. That is the leading case. When the employer disputes 1997 1 SCC.
What is the name of the party?
ESIC versus F5 or Bangalore. I have not brought that.
Yes,
The citation is there.
I mean, what is the law settled there? Law laid down there?
Whenever the employer disputes the quantum of contribution or liability, he has to approach the appropriate forum. That is the employee insurance. That is, my lord, after 1 year. That is after 1 year of the order. Order ହେଲା
ଆପଣ approach କରନ୍ତୁ. To approach the Employees Insurance Court
under section 75 of the Act.
25 of that. ସେଥିରେ limitation କେତେ ଅଛି?
ସେଇଟା limitation 3 years.
3 years.
That your lordship can condemn. As did.
Today the date is 3 years ହେଇନାହିଁ.
ଏଟା ହେଲାଣି order ଟା
24/1/23 order.
ଆଜ୍ଞା 24/1/23.
Mr. Ramesh Chandra Rao for the petitioner, Mr. Amarendra Prasad Ray,
Tripathi.
along with Mr. Tripathi, Mr. D.D. Tripathi,
ND
Tripathi, Mr. N.D. Tripathi for the opposite party, corporation. The petitioner before this court is a proprietary firm. Proprietary firm. It challenges the order dated 24/1/23.
ନାଇଁ 24/1/23
24/1/23 ତାଙ୍କର ବଦଳି ଯାଇଛି
ପାରା 3 ରେ ଲେଖିଛନ୍ତି
କଣ ହେଲା ଓହୋ 24/1/23 on first under section 45 dash capital A of the ESI Act. Directing to pay the contribution totaling to rupees 3,23,978 for the period from August 2017 to April 2018. In view of the statutory provision 75A,
75(1)G.
75(1)G, petitioner has efficacious statutory remedy available to him. The Section 75(1) into 75 into bracket 1 into bracket small g of the ESI Act 1948 is reproduced herein. Over 3 years ta kothire achi Mr. Tripathi?
My lord.
Section 77 1
77.
as capital A provides every such application shall be made and 77
1A.
77 1 and 1 at a code quoted. 77 dot into bracket English 1 then 1 dash capital A of the ESI Act are reproduced herein. It is submitted by the Learned Counsel for the petitioner that the subsequent order under challenge, subsequent order ta kete buchhandi 8/4/25.
That is the Garnishi order.
The Garnishi order is also under challenge, that is 8/4/2025.
26/2/24.
Annexure 5 देखिले page 22.
Annexure 3 ଗୋଟେ ଅଛି.
Annexure 3 dated 26/2/24.
5 ଟା reply ଟା ତାଙ୍କର ଯୋଉ appeal ଟା କହୁଛନ୍ତି.
5 ଟା ହଉଛି ଆପଣଙ୍କର
reply ଆମର deputy director ର reply ଟା ସେଟା ତାଙ୍କର ଯୋଉ ଚିଠି ଟା ଦେଇଥିଲେ appeal କହୁଛନ୍ତି ସେଟାର reply.
It is submitted by the Learned Counsel for the petitioner that Garnishi order under section 45 capital G of the ESI Act dated 26/2/2024 has led to the cause of action. Therefore, 3 years has to be calculated from 26/2/24. The Learned Counsel for the ESI Corporation submits that the order under section 45 dash capital A 12/1/24/2023 has to be challenged under section 75 1G small g. But it is submitted by the Learned Counsel for the petitioner that the petitioner सेटा 45 1G रे सेटा annexure 1 टा आपण रिसीव करछन बोली किछ लिखिछन से कोन लिखिछन किछ लिखिछन
से हां सेटा पाइचंती बोली अटेंड भी करिसंती पर्सनल हियरिंग
कोन सेक्टर से कोन सल्ला ई जस्ट टू डू सेक्टर से सॉल्व कर But having heard the Learned Counsel for the petitioner as well as the Learned Counsel for the ESI Corporation, in considered view of this court, in view of the statutory mandate as well as statutory provision for filing of appeal, no purpose would be served in keeping the matter pending before this court. कितने दिन में appeal file करिवे? 1 month. माने 23 मसिया परे आज हेलानी 26 तापर आउरी 1 month. बढ़िया तो ठीक अछि accordingly it is directed the petitioner shall file appeal before the
employees insurance court.
employees SL for apostol employees insurance court within a period of 3 weeks from the date of receipt of the certified copy of this order. The appeal shall be filed along with the certified copy of this order. Upon it, original किसी file करचंती? No. The copy of the original documents filed before in the writ application shall be substituted with attested photocopies, if so required by the petitioner. Upon filing of the appeal, the learned employees insurance court shall not detain itself on the ground of limitation of 3 years and shall proceed to adjudicate the matter in accordance with law by giving opportunity to the parties The writ petition is disposed of.
Item number 15.
That's item number 15 on behalf of Satyajit Matra, I prepare an adjournment.
Mr. K.K. Sethi,
Yeah, Lordship.
on behalf of Satyajit Mahapatra for the petitioner. The adjournment is sought for on behalf of the Learned Counsel for the petitioner. Accordingly, the matter shall be listed for fresh admission in the week commencing 3/8/2023.
20.
The Learned Counsel shall address address regarding the issues noted in the order dated 7/5/2026. 20th April. 20.
Item number
Narada
20.
Prasad Das for the petitioner.
Madam, 20 minutes, I'm permitted to withdraw my order. Already opposite by died.
Maintenance देलेनी आओ अथवा पड़ियोनी.
A dispute between daughter and mother, madam. At the instance of one daughter, mother filed the maintenance application. And Lorna Judge family go directed to pay 1,000 each, except and in the meantime,
The matter being listed for fresh admission
orders
is taken up. The matter being listed for orders, the memo of date is filed by the Learned Counsel for the petitioner, which states thus. Memo shall be taken on record. The memo shall be taken on record. Scanned copy be updated. The petition stands disposed of. So, Ponda, can you the memo?
No, my lord. He is not appearing. Last date also he is not appearing.
Niranjan Ponda to regular appear করছো.
Aji na.
ଆପଣ କହିଥାନ୍ତେ ମେମୋଟା ତାକୁ ଦବା କଥା କପିଟା ଆପଣ ତାଙ୍କ କ୍ଲାଏଣ୍ଟର ଡେଥ୍ ପାଇଁ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଗଲା he should know at least.
I will inform.
Yes.
23.
Rabindranath Pushti for the petitioner. Affidavit file ହେଇନି. Dismissed. ଆପଣ କିଛି ଆପଣ ଅର୍ଡର ପାସ୍ କରୁଛନ୍ତି କି? ଆପଣ ଥରେ ହିୟରିଂ ହେଲା 7/5 ରେ ଆଜି ଆପଣଙ୍କର ହେଲାଣି କେତେ 1/7 ହେଇଗଲାଣି. Whatever, sir, I have pleased or displeased the material. Rule of law must prevail. On 7/5, you have sufficiently been accommodated. So tomorrow, day after tomorrow. Instruction now ନିଅନ୍ତୁନି ସେ ଆପଣଙ୍କ କଥା ଶୁଣିବେନି. This is just wastage of time, blaming the court for pendency and the jamming of the board also. जो मैटर किसी प्रोसीड करिन छोड़ा काहे बारंबार लिस्ट हो. लास्ट चांस फर्स्ट चांस किछि नाही से अर्जन हे जो. Mr. R.N. Pushti for the petitioner. The matter was earlier heard at some length, and the propositions of law as well as the facts of the case were noted in the order dated 7/5/2026. The petitioner had adjournment to file affidavit as directed at paragraph 4 of the said order. Stop. Though almost 2 months have passed, the petitioner has not filed the said affidavit. Today, again, adjournment is sought for by the Learned Counsel for the petitioner. Adjournment is granted reluctantly. The matter shall be listed for orders in the week commencing 27/7/2026. Yes, next. Yes.
Item number 34.
Cover कर दीजिए up to 30 जाए पड़ जाए नहीं कि
33 जाए 33
हाँ
33 बोलो
हाँ 34 sir.
34.
Lordship, in item 34, I'm appearing on behalf of my learned senior Mr. Vishnu Prasad Pradhan. He is on his legs.
So Mr. Pushti wants, you agree for a date
Because
Next week.
entire evidence has already been recorded and the date has been posted to tomorrow for argument.
କାଲି ତ ନେଇ ହବନି ଆପଣ କାଲି ଟୁମୋର ମାନେ ଆପଣ ଚାହୁଁଛନ୍ତି ସେ ଯୋଉଟା ଆର୍ଗୁମେଣ୍ଟ ପାଇଁ ରହିଛି ସେଟା ଆର୍ଜନ ହେଲେ ଚଳିବ ନା ଆପଣ କହୁଛନ୍ତି
ଆର୍ଜନ ହଉ ସାରଙ୍କର ଆକୋମୋଡେସନ ଅନୁଯାୟୀ ଡେଟ୍ ବି ରହୁ କିଛି ମୋର କହିବାର ନାହିଁ
ଆର୍ଗୁମେଣ୍ଟ ପାଇଁ କହୁଛନ୍ତି କାଲିକି ରହିଛି
କାଲିକି ରହିଛି
ତ ସେଇ ମ୍ୟାଟରଟା ପ୍ରୋସିଡ୍ କଲେ ଅସୁବିଧା ହବ ଏଥିରେ ଏଠି ଟେକ୍ ଅଫ୍ ହେଇପାରିବନି
it will be infructuous. That is the problem.
Mr. Bia, you are Mr. Sahoo.
I am HK Khandal on behalf of Mr.
Sorry.
HK Khandal, Harish Kumar Khandal.
Mr. Harish Kumar Khandal on behalf of BP Pradhan for the petitioner. Mr. Rabindra Kumar Prushti for the opposite party. The matter is listed for hearing under the heading for admission. The learned counsel for the matter shall be listed for admission in the week commencing 27/7/2026. The CP number so and so, pending before so and so, which is pending, which is supposed to be listed tomorrow, as stated by the learned counsel for the opposite party, shall be adjourned to a date beyond 27 ପରେ ହବ 3/8 beyond 3/8/2026 as will be convenient to the learned court in session of the matter. Yes.
36.
36 ଗୋଟେ adjournment ମାଗୁଥିଲେ ମ୍ୟାଡମ ଏଟା upload କରିଦେବେ actually there is some I find that the orders from 24 last week is pending because of my I have some time constraints. So, but this will be uploaded. Just I have general information for the bar that some still the orders are pending. 24 ରୁ ବି କେତେଟା pending ଅଛି. Last week, last working day ଯୋଉ ଥିଲା Thursday.
36.
ସେ adjournment ମାଗୁଥିଲେ ପଳେଇଲେ ତାପରେ ଆପଣ ନଥିଲେ ଯେତେବେଳେ ସେ adjournment ମାଗୁଥିଲେ ତାପରେ ସେ କହିଲେ ମୁଁ କହିଲି ଠିକ ଅଛି ସେ ଆସନ୍ତୁ ତାପରେ ଆସି ପଳେଇଲେ
ଦି ତିନି ଥର adjournment ହେଲାଣି
ଲାଗୁଛି ସେ ଗୋଟେ ଡେଟ୍ କରନ୍ତୁ 36 ଟା ମିଷ୍ଟର ଗୁରୁଦତ୍ତ କର ଫର ଦ ପିଟିସନର ସେ ମ୍ୟାଡମ ଙ୍କ ନାଁଟା ଆପଣ ମନେ ରଖିଥିଲେ
Krishna Mahapaତ୍ର.
ମିସ୍ MS K Mahapaତ୍ର for the opposite party. Learned counsel for the opposite party seeks the matter is listed for hearing under the heading for admission. The learned counsel for the opposite party seeks accommodation on ground of personal difficulties. The learned counsel for the petitioner submits that the matter has been adjourned on several occasions and opposes the prayer for adjournment. Stop. Taking a contradictory view, the matter shall be listed for admission in the week commencing 27.
May I please? Hello, last day, my lord was after seeing the year, specifically directed, let it come on orders because there is one additional evidence is finding. IE is there. For
liberty to mention କରନ୍ତୁ. Maybe conscious of that, say avoid କରୁଛନ୍ତି. What you are saying is correct, possibly. But let us say liberty to mention କରିବେ ଯେବେ ବି ଆସିବ ହେଲା 27.
37.
Mr. Ashwini Kumar Das for the petitioner. Mr. R. Behra for the opposite party. Mr. Das. Interim order ଅଛି.
Thank you.
The matter is listed for hearing under the heading for admission. It shall be listed for admission in the week commencing 27 na 3/8. 3/8. Mr. Maji is saying that Satish said is fast approaching to 100. Yes. 38, Mr. Mahapatra. Mr. Mahapatra.
38.
Devidatta Mahapatra.
38.
Devidatta Mahapatra for the petitioner. Mr.
I am for the opposite party.
KMH Niyamati for the opposite party.
Well,
yes, this is a transfer application. Are you agreeing for any place?
no, my lords, because they have tried to make out a false case, my lords, because both the parties are.
Then it requires hearing. 38.
My lord.
Posting कर दिया तो गोटे को 3/8. We commencing 3/8.
Let's manage this.
Yes.
This matter can be disposed of subject to my learned seniors approval. But transfer is being sought only from Kendrapada to Bhubaneswar Family Court because there are multiple proceeding pending. But it is not agreeing to that custom and it's having a conflict of court.
VC opportunity, that order I am always passing that.
My lords. So if he's agreeing because my lords, I have a small child, my lords. So and he's also appearing in Bhubaneswar in multiple occasions. For the transfer.
ଆପଣ କହୁଛନ୍ତି କେନ୍ଦ୍ରାପଡ଼ାରୁ ଏଇଟା ଫାଇଲ ହେଇଛି କେନ୍ଦ୍ରାପଡ଼ାରୁ ଭୁବନେଶ୍ୱର
କେନ୍ଦ୍ରାପଡ଼ାରୁ ଭୁବନେଶ୍ୱର
Yes, Mr. ନିୟାମତି ଭୁବନେଶ୍ୱର ହବ ନା ହବନି ସେ ଆପଣଙ୍କ ଚାହୁଁଛନ୍ତି ଆପଣଙ୍କର valuable and
ଆମେ ଚାହୁଁଛୁ ଆଜ୍ଞା କେନ୍ଦ୍ରାପଡ଼ାରେ ବିକଜ ବହୁତ ଫଲ୍ସ ଷ୍ଟେଟମେଣ୍ଟ ସବୁ ଦିଆହେଇଛି ପିଟିସନରେ ଆଇ ୱିଲ୍
ଏଇଟା ସାର୍ ଆପଣ ଏଟା ଟ୍ରାଏଲ ହବ ମୁଁ ଏଟା କଣ କ୍ରସ୍ ଏକ୍ସାମିନ କରିବି ଆପଣ କ୍ରସ୍ ଏକ୍ସାମିନ କରିବେ
on the face of the record
ସେ କଣ ଲେଖିଲେ ଛାଡି ଦିଅନ୍ତୁ ସାର୍ Mr.
but it's on the face of the record
no the practice ଆପଣ ଯୋଉ ଟ୍ରାନ୍ସଫର ପିଟିସନ ରେ ବହୁତ କଥା ଲେଖା ହବ ତାର ତ ମେରିଟ ରେ କିଛି ଇମ୍ପାକ୍ଟ ନାହିଁ ନା ଆପଣଙ୍କ ଟ୍ରାଏଲ ଟା ଚାଲିବା କଥା ଚାଲିବ ଆର୍ ୟୁ ଆଗ୍ରି ଭୁବନେଶ୍ୱର କଟକ ଆଗ୍ରି କରୁଛନ୍ତି କି
ଭୁବନେଶ୍ୱର ତ ସେ ଜାଣି ଶୁଣିକି କରୁଛନ୍ତି ଆମେ ତ ହଇରାଣ କରିବା ପାଇଁ ଆମେ ରହିଲୁ
So Tale, I am disposing it of that it is not being transferred, it will continue at Kendrapada. But the parties shall have the liberty to appear through VC in accordance with the rules. They are being made for the state purpose. Yes, disposed of 30.
39.
May I please, your lordship, I'm on VC. Mr. Patnaik is not available because his brother-in-law expired today morning. So he's there for cremation.
It's Madhusnath Rautre on behalf of R.K. Patnaik for the petitioner, to Diptiranjan Swami for the opposite party, learned counsel for the petitioner is indisposed due to personal difficulty. Adjournment is sought for. The matter shall be listed for admission in the week commencing 3/8/2026. Arabor sentence likhibe. The matter is listed for hearing under the heading for admission.
Obliged.
Item number 40.
Mr. Mishra was here. Mr. Abhilash Mishra for the petitioner. Mr. Apananga Nada, sir? I'm sorry, I forgot your name. Mr. K.M. Hathi for the opposite party. The matter is listed for admission, for hearing under the heading for admission. It shall be listed for admission in the week commencing 3/8/2026. और पास होता किसी नहीं
ना
Yes,